Let's do a recap of what we did yesterday. So, want to hear from you. What do you remember from yesterday's interactions and discussions? So, please tell us. What were the key takeaways from yesterday? Oh, no one is talking. Okay, then let me start mentioning names. Mr. Hayford. Oh, okay, that's fine. Okay, then let me move to Mr. Yenchi. I hope you are still using Kojo Boateng.
Okay. So, use the card. Okay. Good morning. Good morning.
Good morning.
So, thanks very much for yesterday. So, yesterday, I think we had a lot to learn from with respect to the the sessions you shared with us. The one on mediation and the one on the ADR. The key takeaway is conflict is inevitable. Conflict resolution is transformational. And we, as participants of this training, are willing and ready to also help ensure that there is peace, there is a general understanding, commitment to actually de-escalate. You also shared with us the essence of the association, why we need to join, and then the work you are doing, the fruit and benefit it has for everyone. I mean, the practitioners, the field, and I think going forward, we also learn about the principles of ADR, what it is, what we need to do as practitioners. Then going forward, we also looked at the mediation bits that actually gave us the nuance of what we ought to know going into mediation, keeping our neutrality, being non-judgmental, and working or being facilitators to help the various factions arrive at favorable or arrive at their own conclusion in resolving the conflict. Yeah, so basically, these are tidbits of what I've gathered so far. Thank you.
Okay, great. Thank you so much. Let me also hear from you, Gloria.
Yes, thank you so much. We learned quite a number of things, starting from what a conflict is, the various actors that we need to take into consideration, and the last bit, I think I got on the principles of mediation, which is neutrality, voluntarism, confidentiality, and impartiality, in ensuring that these principles are adhered to whenever we are engaging in mediation processes. Thank you.
Okay, thank you. Christine.
Actually, so yesterday we got to have a general overview of conflict, the causes, what brings about conflict, and then also not all conflicts that can be solved. We got to know that not all conflict that can be resolved through ADR, and then in as much as conflict brings about disruption, conflict also helps us to check reality. It has reality check. It has some negative and positive side as well. And then we also got to know about how various people react to conflict. And then we got to learn about all the ADR or ADR and other conflict resolution method, which we have arbitration, we have conciliation, we have a litigation, among the others. And then we also got to learn about the various stages when you are doing mediation, what exactly mediation is, and then the various stages you go through when having a mediation process. Thank you.
Okay, thank you. Okay, Reverend Doctor, we want to hear your thoughts from yesterday's.
Good morning, sir.
Good
And
morning.
good morning. I hope everybody had a sound sleep by God's grace. Yeah, yesterday we had 3 presentations, or should I say 2 presentations, almost the conflict aspects. I think it was almost done when I came in, but I learned something about causes of conflict, resolutions of conflict, and the rules or the principle governing or causes of conflict, sorry. Then that was one of them was resource-based conflict, value-based conflict, psychological conflict, communication-based conflict, perception in conflict. Then we've also learned the stakeholders analysis or actors that involves in conflict. And mostly when we are dealing with conflict, we should be neutral. We should be able to look at what actually causes this conflict. And there was this illustration on the paradigm shift where the iceberg, maybe you may be looking at the top, what you are just seeing, or the surface part of the conflict, but deeper to it is more than what you see. So sometimes, in order to be able to know what actually causes it, it's good to do a background research or investigation a bit to know some of the factors that is causing that. And in conflict, we may try to solve some of the issues to become its minimum, but we cannot actually solve all the questions in conflict or the solutions. So in conflict, as much as we try to solve some of the issues that brings about the situation, we should also have it in mind that it is possible that it is not all that you'll be able to do it, but putting in your best, you'll be able to arrive at a certain stage. There will be peace. Thank you so much.
Okay, thank you. All right, so thank you all for the various insights that you've shared. Veronica, were you with us yesterday? Hello, Veronica Bannerman Williams. Were you with us yesterday?
Hello. Good morning, please.
Good morning.
Please, yesterday I wasn't present.
Okay. Yes, because
Yes.
I could see that. Okay. Thank you. So thank you all for the insight that you shared. So yesterday, as a recap, we did overview of conflict. As you have said, we got to know the various um, types, causes, categories of conflict, and also the stages that we can take to resolve conflict. And we move on to the conflict analysis, where we look at the various aspects of analysis so that learning from the medical sciences, we as conflict experts too can also analyze the conflict situation, but we don't look at only what we are seeing, but not as what the ordinary person on the street will say, but we will go behind the scenes and do thorough work and bring out the issues, the underlying issues that is bringing the conflict. That is the causal effects to bring them out. And so we're happy that you joined once again today as we move on to the second day. Then we move on to what we call overview of ADR and ADR spectrum, where we learned about what ADR is as alternative way of resolving issue, but it is not an alternative because that is a name, but it's not actually alternative because it has been in existence even before we're introduced to the core system. So the question one has to ask is that if ADR is alternative, how were our African parents, our forefathers, resolving their disputes when they didn't know about core system? And that is why we introduce you to the Palava system where uh, parties or communities used to have a place, specialized place, whether under a tree or a Palava hut, where they used to sit to discuss issues affecting the community and also resolve conflict in the same way. We know that we used to use festivals or we used to use client hairs and penny, and which is still available. These are methods to show that when we are talking about mediation, arbitration, conciliation, it is not new, just that it is a name and nomenclature that they have created for it that is making it like something which is new. It is not new, it has been part of us. So well, that is why you were introduced to the various mechanisms. So ADR is just an umbrella. When you look under the umbrella, you see spokes. So the spokes are the mechanisms under the ADR. And we look at negotiation, mediation, arbitration, ombudsman, and for you to know the differences. And after that, we look at mediation, look at what mediation is and what mediation is not, the various types of mediation, and also to compare mediation with other mechanisms and also look at the mediation process. Today we are going to take the mediation a step further and we are going to learn more about mediation today. After today, you should be able to start thinking of being able to resolve an issue. So I am going to start by showing you a video. Please pay attention. I want you to learn the processes that the person will use, how the person will welcome them. The one doing the mediation is the mediator, how you welcome the parties. The parties will have give them a seat, look at a certain position, and also how he will conduct the process. He will prepare them, he will prepare the parties, and allow the parties to also give their opening statement, where he will break them for caucusing, as it was mentioned yesterday, and how he will bring them back to the joint session and the agreement that they will make, how the caucusing will shape the entire mediation activity or the process. So please take your time, watch this video as I've said. So the things that I've outlined, take your time and observe them gradually. And after that, the presentation will follow so that it will be a picture of what the presentation that we are going to do today. So it is an eye-opening video that we want you to watch, and this will serve as a mediation in practice video that you need to understand. Because if you want to practice, you must be able to perform like the person who will be performing in the video, right?
Both parties to the mediation
Can
session.
you hear can you hear the sound from the video so that I'll know that you can hear. I only hear your feedback.
And introduces himself.
Can you hear the sound?
Yes, we
Yes.
can.
Great. Okay, so once you can hear the sound, I am going to introduce this video to you. Right, so let's start.
The mediator welcomes both parties to the mediation session and introduces himself. The mediator thanks the parties for choosing to use mediation as a possible solution of their dispute. After a formal introduction, the mediator explains the principles of mediation, in particular confidentiality, impartiality of the mediator, voluntary basis of mediation, and the rules of a mediation session. Both parties are asked to approve the rules and whether they need any explanation of the principles of mediation. There are no questions. The mediator stresses the fact that all the principles have been described and explained in the written contract that has been signed before the session. The mediator also explains that both parties are the only ones who are responsible and able to find the solution of their mediation. After this introduction, the mediator asks whether there are any questions.
Thank you for agreeing on a place and time to meet and for being present today and very accurate. Thank you both. Now, as you know, my name is Georgi Olenkov. You could freely call me Georgie. I prefer first names. And I do work for CDR Associates as a professional mediator. It would be my honor today to assist you in trying to solve your commercial dispute amicably. Now, just very briefly, prior to beginning with the actual negotiation, I ought to say that today we'll be reasoning out solutions for your commercial dispute so that the present situation within the company you're holding together will be altered in a way that will not affect adversely any third parties, the functioning of the company itself, or the provision of quality services, which you both stated in the pre-mediation discussions and as being of utmost importance for you. So now I ought to say that mediation is an entirely voluntary process. You're here because this is your business decision and your willingness to try to reason out jointly solutions for what you're facing. I do not have the authority, nor will I attempt at any point to make any decisions on your behalf. I'm not here as a judge or an arbitrator. And also, I will try to maintain throughout the whole session my utmost impartiality. So please know that I do not hold any preconceived biases towards any solution to your commercial dispute or towards one of you over the other. So should at any time you feel that my impartiality is compromised, please bring this behavior to my attention and I'll try to alter it. Once more, you're here because this is your mediation. At any point, you may decide to stop negotiations, replace the mediator, which I strongly advise you against, and also pursue other means of settlement, though I strongly encourage you to give a chance to our meeting today. So, the floor will be yours in a minute, but first, just two procedural guidelines. The first one being the following. At some point, you may want some break from the joint session and you may wish to meet with me privately in a separate meeting or the so-called caucus, where we shall discuss matters that, for instance, you feel uncomfortable to bring out in the joint discussion. This is an option for you, so keep it in mind. And also, what my experience tells me is that it's good to start in the very beginning of the session with some uninterrupted equal time for either party to explain their perspective, how they perceive the case at hand, what brought them to mediation. So should this idea for uninterrupted equal time be okay with you?
Absolutely.
I would like to begin in this way. All right, then thank you. I think we can start. And Mr. Sharp, you were the initiator of this session, so maybe you could begin with the elaboration. But prior to that, just tell me who you are, what brings you to mediation today, and give the floor to Mrs. Smith to do the same. Then, if that is okay with Mrs. Smith, you can begin with your elaboration.
Okay, thank you. So my name is Jan Sharp, and I'm the shareholder of the company No Need to Pay Limited. I have the 50% of the shares, and
I have
my
the other
colleague-
50.
Yeah, she's
the shares.
that's
My
the
name
problem.
is-
That's the biggest problem.
Well, my name is Julia Smith, shareholder in No Need to Pay.
Yep. Unfortunately.
All right. So please.
So the company, we are working in the field of the tax optimization and tax consulting, and we established the company in 1992. From the beginning, the company was working very well. We earned a lot of money. We have a lot of clients, and the business was increasing very highly and very rapidly, I would say. So both of us were very happy. We earned a lot of money, so we just started to do another businesses. We bought four houses, so we work in the real estate area as well, and also we do the training for the tax professionals. This is the activity of our company right now and from the beginning. According to the fact that the business increased very largely and very rapidly, we divided our activities between us. We are both tax professionals, so we provided our clients we used to provide our clients with our services. And I'm specialized in the client acquisitions, and she is supposed to work in the area of real estate and the training. So that's the basic situation right now. And everything was working perfect. A very long time. We were kind of happy, I would say. We were friends. Everything was perfect. About 1 year ago, something happened. I really don't know what, but something happened. We are not able to cooperate. We are not able to work together. We are not able to communicate. And right now, the situation is that I'm the only one who works for the clients from the beginning till the end. I'm the only one who makes the profit of the company. And I'm the only one who does all the activities of the company. And she doesn't do anything. She's saying, I'm working for the real estate things and the training, but it's not sufficient. Right now, I don't want to be useful idiot anymore. I'm the only one who earns the money, and she's just
Come on,
getting all the 50% of the profit.
Me?
No, that's the
Are
truth.
you kidding me?
Do
that
I look like that?
The only one
Yeah, I'm the only one who earns the money, the whole money. So I'm the only one who works 24 hours.
Where the money comes from? I'm sorry
from
for
the clients.
being
From the
curious,
clients, I get the clients. I work for the clients. All the clients. We are the taxation. We are the company that works for the client.
We are a training company.
Training company. It's a completely different company than I have.
Well, then maybe we have different companies.
Yeah, it seems to be. So let's finish this, settle it down.
Okay.
I will get the money and get rid of this company. I will with you completely.
If I may step in, I think this was useful. This little confrontation
It's true. It's not only useful. It's
let some steam go off. So now
I don't know.
At such times, I always bring the parties back to the procedure that we chose together. And the procedure was the following. Each party talks uninterrupted. And then the other party explains. So please, as you know, a pencil and a pad have been distributed to both of you. So while the other party is speaking in this very beginning of the session, please jot down any observation or remark you have. We will discuss it in detail, I assure you. So thank you for this. And now, Mr. Sharp, do you wish to elaborate on anything further? Or
I think the most important things were said, but right now I'm the only one who works for the company, who earns the money. So I think I deserve 70% of the profit, and I think we are not ready to cooperate. Yeah, 70%. Yeah, that's the thing.
70%.
Yeah,
like
7.
Like 7%. Like 7.
Yeah, I know the number. Yeah,
Because it's not 70. I'm sorry, it's not 70 that you deserve.
70 is 70.
No.
You
deserve
you
the
have to see it. You know it.
I do not know anything that's
So
not
now
based
you
on
know.
the facts.
Now you know.
No, I had
So could you just tell her that make some notes or something. I'm the one who's in charge right now.
Tell both of you that we should stick to the procedure. I know it's hard. I know you mentioned, both of you actually mentioned, even though Mrs. Smith still hasn't got the chance to explain her perspective, you mentioned this communication discrepancy between the two of you. It is visible right now, and I see it's difficult to start discussing in such an informal manner through mediation. But please, let us try in the beginning to stick to the procedure tightly. And Mr. Schaap, could you just continue if there is anything else you'd like to bring about?
Maybe that's all. I'm just the one who's working, so I think I deserve 70% of the profit.
All right, so to echo what you said and what I think grasped from your presentation, and to recap it, you are concerned that there is unequal division of labor within the company.
And profit.
And even though you noted that prior to the discrepancy that occurred 1 year ago, everything was functioning, or if I quote you here, working perfectly. So right now, of course, matters altered in such a way that you would like to sell the company and to divide the profit 70 to 30. Is this a fair recap of what you...
I think it's not only fair recap, but fair settlement as well.
All right, so thank you for this. And now I would like to ask Mrs. Smith to present her perspective.
Well, there's not much to say. Thank you for that. And yes, it is. It was and it still is very harsh for me to be here to address those issues. But we are where we are, and we need to confront what brought us here today. I can agree that, yes, we initially were very profitable. Shareholders of no need to pay LTD. We set it up as a business adventure, I would say. Part of the business plan in the beginning was that what we'll be doing is tax consultations, and yes, Mr. Sharp, acknowledgement to him, is good at that. I'm also good into this. So we were having clients and servicing them with our tax optimization structures. But that was at the very early stages of the company's development. Later on, we moved on to the real estate management. And today that's like another aspect of the company. I would say like a separate division. It's like a subdivision of the company. An entirely different business from tax services that we used to, and we still are providing. No question to that.
I am providing.
And that's today.
Yep.
But in addition to today's work, we also have trainings for tax professionals, and that's entirely on my shoulders. This is part of the business that I'm in charge of, and I think that perhaps because Mr. Sharp doesn't get to see it day to day, he probably doesn't even know that it exists. But if you look into the accounting, you'd see that a lot of the cash flow comes from those trainings that we provide for tax professionals.
No, sorry, Mr. But I have to say something about that because I have the documentation, the tax documentation. There is no profit, no huge at all a huge profit from this branch of our enterprise company. Nothing. It's just the 30%. This is okay. 70-30. I don't have a problem with that.
Because I've heard the 70% number before. Like this has been on the table always, and I don't see it. Like for him, it seems like everything's about money. Money, and no intention whatsoever to look into the matter and where we are. We have a potential with this company. He just doesn't get to see it because he doesn't.
Company.
I can disagree, but because I've heard you argue many times the 70%, and I've never heard even once for a change any argumentation of the basis that you used to come up with the number.
Did you see the numbers? The profits of the company?
The
client, the money that the clients are paying.
And you may
Did you see
be interested in seeing this document, and I'm sure that the mediator is going to be interested. This is evaluation of the assets we hold.
Well,
and
I have all the documentation that we need, and that is saying that more than 70% of the profit goes from our clients. Clients that are
where are those clients? I don't see them.
Well,
I don't see them. I don't see clients.
Maybe you should leave the houses and sometimes go to the office and see the people.
Tell me this. No, that's absurd.
That's the situation.
So, anyway,
see the account. See
what
the account. Who's paying for our bills?
Okay, I'm not going to go.
This is the
I'm
point.
not going to go to your road. So, my suggestion is You don't want to work with me? Fine. I don't want to work with you either. Okay?
Perfect.
We can agree on that. What we can and should agree then is how we part. And I suggest we part with grace, which means sticking to our initial word, which is 50-50.
But the situation changed a lot.
That's the profit division we agreed on.
But from the beginning, it was 50-50. I agree. There's no reason not to agree. But right now, the situation completely changed. I am earning more than 70% of the profit of the company.
No.
And you are getting 50%.
Now, if I may step in, just Mr. Sharp, please consider the initial procedure that we all agreed on. And just as I asked Mrs. Smith while you were talking, I would also advise you to jot down any remark that you have. We will discuss it in detail. Just let Mrs. Smith, should that be all right for you, to continue with her elaboration. So what else do you wish to share at this point?
I don't think there's much more to say. You see the exact status of our communication, and it's been like that for the last 12 months. So obviously we cannot work together, and I can agree that if you want to put an end to the business, all right. I mean that's where we are. Fine by me. But what I cannot agree on, and this is my position. We may discuss if we want to continue and how we want to continue, if that be the case. But if we are not to proceed with the business, and if we're to liquidate no need to pay, I'm very, very much, I cannot agree to his 70%. My position is we stick to the division of profits 50-50. That was the initial plan. I'm not requesting for more because I trust that part of that share, I have grounds to ask for more than 50%. But I have the honor to say that this was the initial plan and this still is the plan. So that's my position.
All right. Thank you, Mrs. Smith. So I actually thank you both for your patience, for
somehow.
your elaboration. Please.
She's acting like a generous lady, but she's
Who
not
I
generous. She wants 50% and she deserves 30 maximum. So it's very easy to prove it. She said she has some text documentation.
Go prove it in court, okay? I mean, if that's the conversation you want to lead, go prove it in court. Okay, I'm fine. Go prove it in court.
Then this session is useless if
I'm
you're saying
that
this
we're
way.
coming here to have some discussion, right? I mean, let's listen to him for a once, okay? He may have something to say.
I just
Let's
as you said, you have the documentation. I have the documentation as well. So let's see the background and say, okay, you are earning this money, you are earning this money.
All right. I know, first of all, I understand that all of this is very, very hard for you after 1 year of turbulent communication or lack of communication to sit here at the same table and to discuss these matters with the help of a third party. I understand it's hard. I also understand that you came here quite prepared with the relevant accountancy documentation that we may easily delve into, should that be the way you perceive this negotiation today. Yet once more, I urge you to stick to the procedure that we chose and to try to go patiently through all the topics. For instance, at some point you started discussing the 30 or 70% or the equal division of the profit from the company should it go liquidated. Yet this is a solution to one of the two scenarios that you perceived, which is either continuing with the company or not. So let's just go patiently through all of that. And before we do it, let me just recap what Mrs. Smith just shared with us. And it is briefly the following. Please correct me if I'm wrong with anything. But from what I grasped, you perceive that there is equal division of the workforce within No Need to Pay Limited, that with view to the sub-branch of the real estate and to some other occupations and obligations of yours, you deserve to receive, should the company be sold, an equal amount of the profit. And you also mentioned, just as Mr. Schaaf, that communication is a very important matter in your commercial cooperation. So, what my experience tells me is that it's also always very good to have some plan or some agenda to give structure to our discussion, to give some firm ground beneath our feet. So to help you with this, I came up with three main topics from what you just shared, three main topics that seem to be utterly important for the two of you today. And these are the following. first, of course, your shareholding within the company. Then the second topic would be the possibility of future business together. And of course, the third matter, communication, the word we keep repeating throughout this session. So can we consolidate that these three topics represent a fair recap of what we ought to discuss today?
I can agree to that here. Yeah.
So should this agenda be also all right for you, Mr. Shah?
Yes, but I don't think we are able to cooperate in the future. But if you want to make the agenda like this, I don't have a problem with that.
We can just put it down on the flip chart just as a possibility.
Okay, then I'm okay with that.
So now that I mentioned the flip chart, one of the most useful tools in the toolbox of the mediator, I would like to write down the three main topics in this agenda that we consolidated on. So one of the topics could be the shareholding of the company. I just write down shareholding. And is this visible? Another topic may be the so-called future business together. And in this ambiance of mediation, I take the liberty to underline the word together. And the third theme, the third important topic, which you both considered as being very, very important for you, would be the communication matter. So, as you can see, I'm deliberately abstaining from enumerating the topics. You may conduct your negotiation in any manner you want. This is just to give some structure to your dialogue. So, this is the agenda that we jointly came up with. So now, as I told you, I have not enumerated the topics. It is entirely your joint choice to choose how to proceed and with which topic to enter this discussion. Please.
So may I suggest we start with the communication? I believe this is the root of our problem. I believe communication is also the way to solve our problem. And I think it would be very useful to really have a way of communication, a way of listening to each other, a way of hearing each other, a way of even being heard. So I suggest we spend some time on this because...
All right, how do you perceive this, Mr. Shah?
I don't think it's necessary. It used to be very important. We cooperate. Right now, we're not cooperating anymore. So...
How are we going to solve the problem then if we're not able to talk?
So you have numbers, I have numbers. We have a mediator, so we can just make some ending with that, just to say how much money I get.
But
that's all. It's about business, just business. We don't need to talk about
it looks like we have an invisible elephant in the room and we are not allowed to speak about it. Then what are we doing? We're not addressing the issues at hand.
Well, we're speaking about what you do, what I do, what you deserve, what I deserve. That's simple. It's business. This is the thing that I can. No communication. It's important, I know. It used to be much more important. It used to be friends, but right now, it's not important anymore. Right now, I just want to finish this thing, to sell the company, get the money, put my energy, my time, and the money I earn or I get into something else, something much more important for me, much more personal for me.
Yeah, but we're friends, come on.
We used to be friends. The last year, you saw the last year. Every single conversation.
You're not making it easier for me.
Okay. I just want to settle it down. I need to settle it down.
You cannot separate things. You cannot separate personal and business. Yes, in an ideal world you can, but they're intermingled into each other. So if you have something personal that I'm not aware of, I cannot be of assistance to you.
But I don't want to talk about this.
Mr. Sharp, I understand it may be difficult to delve into personal matters, and I just wish to underline once more that we are not in a courtroom, that we are in this informal ambiance of mediation where you could disclose anything you deem necessary and it will remain completely confidential. So I know you disregarded at some point the importance of the topic of communication, yet in the very beginning, both of you shared that something changed 12 months ago, that something changed dramatically after many, many years of successful commercial cooperation. So you, Mr. Sharp, from what I grasped, mentioned some personal matters and that you don't have much time right now to devote to the company. Could I just go, if that is comfortable with you, a step further, just to make sure that we are on the same page, and to ask what it is that, just very generally and broadly, that you need to devote your time and financial resources to presently?
Oh, sorry, Mr. Mediator, but I don't want to talk about this. It's very sensitive for me, and experienced very hard days, or months, maybe a year. So no, I don't want to. I don't think it's part of this. I just want to finish it, get the money, and work on other things that are much more important for me. Maybe the most important thing right now. This is
All right.
my goal, and I
I
don't
do-
think it's connected with the little business.
I do respect your decision, Mr. Sharp, entirely. I do understand that you may be in a difficult situation you don't want to delve into. Now, what I did tell you in the very beginning is that at any time during the session, you have the option to adjourn to a so-called caucus or a private session with me. And I do believe that now would be a suitable time for us to adjourn to such separate meetings. And how do you perceive this as an option?
Well, if you think it would be useful for.
Indeed, I do.
So,
Mr. Sharp, I understand entirely that it may be difficult for you, yet
for sure, it's very difficult. But if you think it will help us and lead us to some settlement, and then
indeed.
I will agree.
I think it will be the perfect solution to this impasse and walking in circles that we found ourselves in the very beginning of this discussion. So, Mr. Sharp, I know it's hard for you. Maybe we could, despite this, begin with a separate session with you.
Okay, let's do it.
Thank you. Mr. Sharp, please make yourself comfortable. Thank you once more for choosing to adjourn with me to a caucus, to agreeing to this private session. Now, in the beginning of your negotiation with your partner, Julia, you mentioned that you worked very fine prior to last year when something in your communication occurred that altered your entire commercial relationship, and that ever since things have not been the same. And Julia called this the invisible elephant in the room, and you said that you would abstain from delving into this, as this is a personal matter for you that is very important. So now, at the outset of this private session, I want to underline that everything you share here shall be strictly confidential, and I will not disclose it to your partner Julia unless you, of course, instruct me specifically to do so. So now that we are in private, could you elaborate more on what it is that you need to devote your time, your financial resources to presently? What is it that is troubling you so strongly?
Well, I can try, but it's very hard for me.
Please, take your time.
Sorry for being emotional, but it's very.
I understand you completely, Mr. Shah.
So I'm experiencing very hard times right now. Like last year, it's very, very complicated for me, I would say. I'm divorced and I have a daughter, Lily, which is 10 years old. And 1 year ago, the doctors found that she's seriously ill. So after I found this information, I have only one option, and this is the health of my daughter for sure. So I tried to find some. Sorry, I will bring please. I tried to find some solution, and they said that I can take care of my child at home, but it takes time, and also some changes in the house must be done. So I said, okay, I will do anything for my child. So I just tried to find some possible solution that cost a lot of money. It costs for the medicine, for the doctors, for the adjustments of the house. So the only option for me is to stop the business, sell the business, get the money from that, and take care of my child, for sure. So that is the reason why I need the money. I know that Julia used to be friends, and maybe it's not really family, but they're very close friends. And after I realized that this problem, this possible complication of my daughter, I wanted to talk to someone. After the beginning was, you can't even imagine what happened if the whole world, the whole life just changed like this, in a very, very, very bad way. So after a couple of weeks, I tried to talk to her and just to explain what happened and what I'm experiencing, but it's impossible to talk because we are just arguing all the time. I'm just trying to say something, and she's talking about business, which is not important for me at all right now. I just want to take care of my child, and that's all. So this is it, maybe. You can. So this is sufficient for you,
Mr. Sharp. It is more than sufficient. I just wish to say, firstly, 2 words, and thank you. Thank you for choosing to speak about this personal trouble of yours in a manner that is so direct and so honest. I believe that honesty is the key in mediation, and especially in this case, with you and Julia, who have cooperated successfully as friends for so many years, honesty is the only right path. And I thank you once more for this. You're in the most difficult situation imaginable. And now it is more clear how what motivates you to, and I'm making a short recap here, to choose as an only option to sell the company and to devote all your time and energy to the healthcare of your daughter, specifically by meeting the doctor bills and also making some necessary house adjustments that you also mentioned. So I said that honesty is the key. Do you think that when we go back to the joint session with Julia, if you choose honesty one more time, and if you share this personal issue with her directly, just as you did right now, this may change the whole climate, the whole negotiation climate in the room. Would that be an option for you?
Well, it's hard to say. I tried a couple of times and we know each other for a very long time, so she has to know that something is happening. I had to change somehow. I'm not joyful anymore, and all this jokes, and it's not working anymore.
Indeed.
So I tried, it didn't work. So if maybe, and it will be hard for me, but if you maybe help me with that, and could you just tell her by yourself?
I will begin presenting this personal matter, yet I feel strongly that it might be best if it comes from you, Mr. Shah.
Mm-hmm. So if you think it would help, I can try it, but still it will be difficult, and I have to say I'm a little bit afraid of the results. It's still hard for me to talk to anyone, especially to Julia, about this matter.
I understand clearly, and with due to that, thank you once more for making this choice of sticking with honesty when dealing with your business partner. So, is there anything else now that we are in private that you may wish to share with me additionally?
I don't think that will be anything else. This is it. This is all. The case is all about this.
Thank you, Mr. Sharp. Then I would ask you for some patience now while I hold the separate meeting with Mrs. Smith.
Okay. Thank you.
Thank you. So, Mrs. Smith, please make yourself comfortable. Thank you for agreeing to adjourn to this caucus. Now, at the outset of our private session, I need to underline that everything you share here shall be regarded by me as strictly confidential, unless, of course, you instruct me to disclose it to Mr. Sharp. So now that we're in private, is there anything that you would like to discuss? Anything you would like to elaborate on that you didn't have the chance to talk about during the joint session?
Thank you for giving me the chance. Well, in reality, and as I said, I do believe we have a communication issue, and I see it very clearly now that he's troubled, and this troubles me as well because I still deem him as a friend or somebody close. So the mere fact that he wasn't comfortable sharing it out loud is pretty troubling, which indicates to me that we have a lot of work to do in order to reach a sort of a solution. I'm hoping that you manage in the private time that you took with him to really open him up a little bit, because I believe what happened 12 months ago has an impact today. And for me, it would be important to get the understanding so as to be able to find a solution. And we'll see. We'll see. I remain open for that.
Yeah, it was very transparent in the joint session, and right now it's also quite lucid that for you it is important to clear out the matter of communication firstly. And I have positive news with regards to this. Indeed, in the private session, you guessed correctly, Mr. Sharp agreed to discuss some very personal, very emotional matters, to discuss them openly and in an honest fashion with you during the joint session. So I have the strong belief that this would alter instantly the whole climate, the whole negotiation climate in the room. So, is there anything else that you want to talk about now that we're in private?
Yeah. Well, first, that's great news. That's great news because I believe that's the key to finding a solution. And as part of the solution, something that I'm ready to share with him is that I'm really, really willing to continue with the business. So my proposal to him would be to buy him out. I see that the business, as much as we have had our challenges in the past, it is something I want to devote myself for, and I clearly see that he needs the money. So from my perspective, we may have a settlement there. It's just a matter of finding the right price for the buying out of his shares.
So from what I grasp, it is an adequate commercial option, a business option for you to buy out the share of Mr. Sharp. And a follow-up question, is it okay for you to present this as an idea during the joint session?
Well, I would first wait for his opening,
I
because I think that might have an impact on whatever solution we come up with. But afterwards, I'll absolutely feel comfortable sharing it with him, proposing it directly with him. And of course, I would rely on your guidance and assistance to help support me in this and to probably find a way out.
Let's hope you do. Let's hope you do.
Optimistic about
So, provision obliges me to ask you whether I could share this with Mr. Sharp.
Yeah, please do so.
Thank you. So, let's now go back to the joint session. Thank you.
you.
So, Mrs. Smith, Mr. Sharp, thank you for your patience and also for your very active participation in the private sessions with me. I think those were very useful in that, for instance, with Mr. Sharp, we managed to tackle the very sensitive topic of the personal reasons for his preference to discontinue his commercial activity within No Need to Pay Limited. So, Mr. Sharp, as we discussed, you're in quite a difficult personal situation, and there are matters that you find hard to openly share. Yet, during the private session, you made the firm choice to try to explain the situation to your partner and your friend, I believe, Mrs. Smith. So now that we are back together, could you please elaborate on this?
It will be hard, but I can try at least. So the situation that brought us here, you remember Lily?
Of course. How is Lily?
Not
Did
very
you
well.
speak about her?
Well, the reason is she's not very well. She's ill for a couple of months right now, and right now I'm taking care of her. most of all because there are some serious problems. She's
Sorry to hear.
it's a very very hard situation for me and for her.
I can understand.
It's very so I'm not able and, to be honest, willing to put my energy and the money and these things into anything else than Lily. So this is the reason why I have to finish the whole company to get the money, because it will cost a lot of money and personal energy, time, and these things. So this is at the beginning of our situation.
So you need the money to support Lily, and you
For sure.
need the time
To take care of her, yeah,
take
because
care of
I'm according to the doctors, I'm able to take care of her and not leave in the hospital but take it to my home. But I need to make some changes in our flat, our house, and also take care of her by myself. So this is the reason I was not able to tell you and why are you here.
Yeah, and I'm really sorry about the situation, and
Thank you.
I'm sure how difficult it is and how depressed you might have felt, and not sharing it with me, I understand how frustrated you were with the situation, and just let me know what I can do, and then
Well, if we can handle this thing, and just to
I'm sure with
make all these things must be done for Lily, I would be really grateful.
well, this entirely changes the scene for me. I now feel totally different, and of course we will find a way out so you can take the care that you need to, and at the same time we can just find a solution to the issues that we already raised.
Hope so.
Mr. Schaap, I do thank you for speaking about this in such an honest manner, and Mrs. Smith, thank you for mirroring this with so much empathy. Now, to give you some structure, from what you shared, on the one side, an important topic presently in your discussion would be the money matters regarding the healthcare of Lily, and also the necessary house adjustments and the resources that need to be allocated for that. So this could be one of our two new topics on the agenda. And also for Mr. Sharp, from what I understand, your most preferable option and business path would be to discontinue your activity with the company. So maybe a second topic could be the company with two possible commercial scenarios before both of you. One of them being to sell the company, and the other being to, and with this I'm nodding to what we discussed in our private session, Mrs. Smith. The second option could be to not sell the company, and there you perhaps would need to elaborate on the specific conditions under which this business scenario will transpire. Is this proposal for a new agenda satisfying for you at this point?
Yeah, I just want to make one side comment, maybe just one addition to this. I already spoke with Georgi about it during the private session, but what I can propose as a way forward is to buy your shares out. I think that may be the fastest way forward, and it would allow you to focus immediately on the most important thing, which is Lily. So take it as a proposal from me as to the options, and I would like maybe to explore this a little bit further if you agree that such a course of
Well, it's new information for me. To be honest, I don't too much care where do I get the money. I just need to take care of my child. That's all. That's the only thing I need and want. But if it would be suitable for all of us, then I would be happy if you continue with the company, because we worked for years in that, and it's working very well. So I would be happy to let it be led by you for sure. But it depends on the conditions that I have to the final settlement that I need the money and
So
arrange to care for my
you
child.
said it depends on the conditions, so let us explore together these conditions. And I again turn to the flip chart just to jot down the ideas for topics that we brainstormed. So, from what we just discussed, I believe we could consolidate on the topic of share, transfer, and specifically on the price for that. So here I turn to you, Mr. Sharp, and I pose the following question. You mentioned that you need to meet some medical expenses on the one hand, on the other hand, some costs for house adjustments. Could you present to us specifically the exact numbers and for each of these different obligations?
So the obligations right now are two of them, and the first one is the doctors, which will cost 30,000 euros.
So I put down bills and the sum of 30,000 euros.
And also we have to pay in a couple of days or weeks 75,000 euros for the medication and other related things.
Okay, so we could put down, if this is okay with you, medication, and the number is 75,000.
Yes.
Okay.
And the last and the biggest are the house adjustments, which will probably cost around 220,000 euros.
Okay, so we can write down house adjustments, 220,000
Yes. euros.
All right. Well, you are the business people, so it is your task now to talk in numbers. So, Mrs. Smith, how do you perceive these expenses that Mr. Sharp presented?
Well, I see that the expenses total to the number of 325,000 euro, if I'm correct in my calculations. And unfortunately, I don't have that amount of money. I don't have 325,000. The biggest that I can pay to you is 275,000. So there is a difference of 50,000 that we are apart from each other.
But
what can we do with that difference? I mean, is there any way we can?
Well, this the expenses I have to spend for sure.
So when do you need the money for? When do you need it by? Is it due now, or you can?
The first two, yes, the bills must be paid in 1 month or something like that.
Okay.
And the house adjustments, it will take some time, definitely. So I have to prepare the house for Lily like in half a year or something like that. But part of the house is supposed to be done in 1 month maximum, just to take her home.
So within a month, you need 105,000 euros.
Yeah, that's the bills. And make the first changes in the flat. It will be like month and a half. But not that's not the biggest reconstruction, but part of it must be done in 1 month, 2 months or something like that. But it will cost some money.
But just for me to understand, and real estate management, I'm in that business. How did you come up with the number? I mean, did you have your contractor that
Not yet.
has given you those?
As you can hopefully understand, I was completely depressed and I'm taking care of Lily. So I just asked some friends or some companies, show them what I have to.
Why don't I help you here? I mean, that's my field. That's my expertise. I mean,
it's new information.
This is absolutely. I'd love to. I'd love to help you. And quite honestly, I think that this. I know your house. I think this amount for refurbishment is a little bit overrated. It could be.
Well, I'm not professional in this thing.
So I think we can reduce the actual number. So if I got my the partnering companies that we actually use for our business, I think we can pretty much reduce the number. And then,
well, to be honest, I don't too much care who's going to do it, and I don't need the money. It's not money for me. It's money for the adjustment. So if the changes will be done somehow, I don't care how much that does it cost.
I actually right now I'm thinking I have like 3 companies that are pretty good. I'm sure they'll make a great job, and actually the pricing would be far lower than this number. I'm certain about it.
If you arrange it, if you are able to assist me in this or
absolutely. do it
make
for
these
Lily as
changes,
well.
then I don't have a problem with that.
Super.
It must be done. This is the only option, only goal I have.
So then, what I will need from you is the floor plans and the specifics that you
adjustments.
need the house to be
Well,
compliant with.
I have it here, so I can send it immediately
Okay,
after our
just
meeting. I will send it to
Send
you.
me the floor plans and
It's
requirements.
supposed to be done very quickly. Like
Okay,
we have to start in 1 month or something.
So maybe
Time
you
is of the
should
essence, yeah.
fix some deadlines, for instance, and appoint another meeting.
Well, I would send it immediately. The information. I don't know how much time
Okay.
do the companies or your colleagues.
So then I
or-
suggest, and the mediator is actually kindly inviting us to do is, I will arrange all the contracting companies that we can use. I will speak with them. I will send to them the floor plans and the additional information that you sent me.
Mhm.
I will discuss it internally. It may be that they need to come and see the house just for a better understanding of what exactly needs to be changed. And let's meet 1 week from now with the concrete information,
No problem.
specific deadlines, designs, so that you can approve it and then we can go ahead.
I'll be happy to.
Now, first of all, just a step back. It's extraordinary how you face these communication discrepancies for 1 year, for whole 12 months. You could not communicate properly. And now, just after some time in this mediation environment, you're discussing concrete proposals. So let me just make sure that we're all on the same page with regards to these proposals. So what you agreed on while analyzing the scenario in which Mr. Sharp's share is transferred to Mrs. Smith is the following. Mrs. Smith would pay the amount of 105,000 euros, which would be due immediately, as far as I understand. And also, she would undertake the obligation to assist Mr. Sharp in the refurbishment and the necessary house adjustments in the house of Mr. Sharp within the next month. So you would contact, you two said that you would take this task home and you would contact the three partnering companies you're using to discuss the floor plans, which Mr. Sharp would immediately provide you with, and also the additional specifications that are required for your analysis. And you would present Mr. Sharp with an option, yet the cap sum, the total amount which you could not exceed, is the total sum of 275,000 euros. Is this correct?
That's totally correct from my side. Of course, I assume that if the total refurbishment is far lower than 275, then we just go with whatever the amount is.
Is this agreeable to you, Mr. Sharp?
Well, I have to have it done. This is the most important thing for me. So if it's going to be done, then I'm okay with that.
All right, then thank you once more. And I brought to the table the topic of specific deadlines and when your next meeting ought to be. You agreed to meet in 1 week. So my next question to both of you is, do you need my assistance and my presence during this subsequent meeting, or do you think you could reason out the matters of house adjustments on your own?
Well, thank you for the offer, but I think with Julia we are
I think
able.
we'll be fine.
Hopefully, we are able to
Yeah,
settle it
we'll
down.
be fine. Thank
All
you
right.
again for asking. We'll keep you informed of whatever we
I would be
outcome
looking
is.
forward to,
Oh, yeah.
to seeing what you have agreed upon in the end. And now I want to thank you, Mrs. Smith and Mr. Sharp, and to wish, firstly, to Mrs. Smith, broad commercial horizons before
Thank you.
No Need to Pay Limited. And to Mr. Sharp, on the other hand, I wish sincerely a speedy and full recovery of young Lily. Thank you both. Thank
Thank
you.
you. Thank you very much.
55,679 euro, and that's the best that they can do. That's the price, and this is without.
Hello, Mr. Georgi Elenko. Oh, Mrs. Smith. Yes, hello. Oh, Mr. Sharp, I can hear you too in the distance. Yeah. So, how are things going 9 days after the end of our mediation session? You did agree. You agreed on the house adjustments, the specific sums. Good. Excellent. I'm very, very happy and rewarded to hear that. Thank you. Well, Godspeed to you both, and thank you to you too. Thank you. Good luck. Good luck.
I'm John Quinn with the law firm of Quinn, Emanuel, Urquhart, and Sullivan. And today I'm going to be talking about mediation process and tactics. Mediation can be a cost-effective means of resolving disputes without trial. Most mediations are voluntary, but U.S. courts usually expect parties to try to meet.
Thank you. Thank you for watching. We are back. I hope you have learned so much lessons from the video, and that is what we are going to use for our next discussion that we're going to do. So keep the video in mind. At a certain point, I'll ask you questions about what you saw in the video, and as we bring those things to bear, you reflect on the videos to in mind, and so that you can bring a good conclusion to what you learned and to build better skills for yourself. Right. So we'll continue today's session after a video. Right. So we're going to look at techniques, mediation techniques, opening statements, signing of consent to mediate, and the rest of the process. Right. So let's see what we have today. So by way of adding up to what you learned yesterday, so mediation is not something that is new. Mediation has been in the system for a long time, and before the colonial masters even came to Africa, mediation was there. So before colonial masters, for example, mediation was utilized in resolution of dispute using elders, counselors, herdsmen, and tribal chiefs as mediators. But although they were not calling it mediation, we are now calling it mediation. They were not calling it mediation. So today, mediation is used in a multiplicity of conflict situations. It is used in resolution of interpersonal conflicts, in labor management, commercial, ethnic, community, and education and international dispute and cross-border dispute resolution. So this is what mediation is being used for. So its growth stem from the dissatisfaction that people have over litigation, because litigation is not able to give them the satisfaction that they need. So this propriety and growth and propriety stem from the deep dissatisfaction with litigation alternative, the lack of involvement of the parties in crafting creative solution to their problem, and shift from focus on right to a focus on interest. So yesterday, you look at the narration which was given by Facilitator Humphrey, where he made reference to the fact that he went to see someone, and a lawyer friend, and whilst they were talking, a client came there, and the lawyer told the client to prepare, because as they are going to the court, anything can happen. And this is what happens, because even the lawyer is not sure as to how the issues are going to be, and what is going to be the outcome of the issue. And so that issue is on right base. And if it is right base, it is somebody that is going to determine for you. So for instance, the judge will tell you what to do, the outcome of the process. And even sometimes you go to the courtroom and you don't even understand what is happening. Sometimes you go to the courtroom and it is a conversation between the lawyer and the judge. All that you hear is that case adjourned, or we would like to take a date. You don't even understand what happened. After the court, your lawyer will explain to you. All these things makes people dissatisfied with the use of the litigation system. And so matters that are amenable to ADL, parties are willing to use mediation instead of going to the court. So some of the matters that are amenable to ADL, some of the matters that you can take to ADL or to mediation. So this has taken a global toll. So mediation has been employed in the resolution of dispute in the following areas all over the world. So landlord tenancy issues, personal injury issues, employment contract, student dispute, land dispute, commercial contract, matrimonial property, wills and estate, parenting issues, commercial and civil matters. So let me say all commercial and civil matters, and also industrial and labor issues. That is why even when you come to Ghana, there is a specialized court in charge to handle various uh, commercial or industrial disputes. So if you look at the National Labour Commission was set up even for that purpose, so that people who go there with their issues can get mediation services there. Then we have family dispute, including issues arising on separation and also divorce. For instance, if you go to court for divorce, the court can allow you to use mediation to do the auxiliary aspect of the divorce, which is the property sharing, custody, access, and those things. The parents can discuss, the parties can discuss, so the couples can discuss these matters. But on the matters of the dissolution itself, it has to be done by the court because it's the government that grants the divorce, the marriage, and it has to take the court to divorce the marriage. No individual can sit in their house and do divorce without the permission of the court. If it is an ordinance, marriage under ordinance, you can't just divorce. So, but under all the other issues, auxiliary issues like the sharing of property, alimony. Alimony is the compensation that parties can pay to each other. Then when you say alimony, it is not only paying, compensating your wife, but it can go either way. It can go to the husband, it can go to the wife. So that is how it is. Then, so community and neighborhood issues, public policy issues, social conflict, and also international issues. So there are many other fields into which mediation has extended in other countries. For example, in academia, in the church, in the hospital, in the healthcare system, in consumer dispute, for gender, race, ethnic issues, and in assessing claims for injuries, and in dealing with farmer-lender debt issues, in dealing with prison grievances, and for many other disparate purposes and complaints by patients against doctors. So now healthcare mediation is also happening where you don't want to spoil the relationship, although the doctor might have made a mistake, maybe leaving something in your stomach, but they can resolve the matter where another procedure can be done to take the thing out and you'll be compensated instead of maybe going to court for the court to now compel them to do that. Why can't we sit down to do that? These are matters that can be done. Like Mr. Hayford narrated yesterday that he bought a land where the other party also bought the same land, and that they decided to negotiate where I'll take half, you to take half, and let me take my balance from the chief. These are collaborative way of resolving matters instead of maybe going to court up and down, and the court will say no, this one bought it first, this one bought it last, and all these things will be stressful. And even land. So for instance, if parties are fighting over boundary issue, boundary clarity, and those things, instead of maybe going to court, so that the court will order that there should be a surveyor for the surveyor to do a composite plan to see where each party's land passes, where the boundary are. Which this matters are matters that you could have discussed among yourselves and have the matter resolved, and without going into that stressful situation, that parties could have sat with a mediator and agree that we want to pick a surveyor so that surveyor can do a composite plan. So all of us will be aware where our land, based on our site plan, where the boundary are, which are simple in nature, but parties can do. But we would rather go to court and waste time till the judge order that this should be done. These are some of the matters we need to also educate people about and for them to take advantage of. Mediation is used in court systems. So the court, knowing the efficacy or know the usefulness of mediation, have adopted it. And all over the world now, mediation has become part of the court system. So when you go to court, you see court annex mediation, court annex ADR. Most of the court annex ADR uses mediation. So you have if you come to Ghana, it is a judge-led process. So parties can request at any stage of the process, and the judge will have the right to or have the discretion to refer. The judge can also suggest to the parties if they agree, they will go and try mediation. If you look at Section 64 of the AD Act of Ghana, it talks about the referral of mediation in the court system. The court in Ghana since 2005, and even the Court Act also recognize the use of mediation in both civil and misdemeanor offenses. Using mediation in misdemeanor offenses is called victim offender mediation, because the criminal system is focused on the offender and how to punish the offender. So victim offender mediation is introduced when it comes to misdemeanor offense. When we talk about misdemeanor, we talk about less crimes. Maybe somebody slapped someone and maybe she got some bruises. We go into the hospital. Who will pay the hospital bills? It is not an aggravated assault. So at the end of the day, what will happen? So there is a need for somebody to pay for the hospital bills and that. So victim offender mediation comes in so that the offender will now be accountable to their actions, so that the other party, the injured party, can also be compensated. This is not done at the private centers. So if you are going in as a private mediator, you don't go and be taking criminal cases, any criminal cases in nature. A private mediator does not go in. It is only the court that can refer such matter to be mediated, maybe looking at the family relationship and the people involved. That is why when you look at the Act 732, that is the Domestic Violence and Victim Support Act of Ghana, it allows the police to mediate. That's why we have those two departments. They mediate on certain matters so that it will help the parties to resolve relationship issues and build upon that. So that is where the police enforcement agency also comes in. Yeah. Then, so looking at adding up to the definitions, the United Nations guidance for mediation, or they have a guidance, or the United Nations, the UN guidance for effective mediation. That was done in, I think, 2012. It describes mediation as a voluntary process whereby a third party assists two or more parties with their consent to prevent, manage, or resolve a conflict by helping them to develop mutually acceptable outcome. So what you should understand about mediation is that mediation thrives on consensus building. So parties must consent that they will go through the process. So unlike the court process where if a party fails to attend upon the court can summon that particular party. Mediation is not like that. Mediation, the parties must consent. They must agree. They must accept to participate in the process. So if you look at here, the mediator is a third party. You, the mediator, having been trained here, you become a third party. So if you are going as a mediator, you are a third party. You are there to assist parties, two or more parties, with their consent. So you seek their consent and you look at how the consent is sought to prevent. So sometimes these matters are matters that you resolve to prevent a conflict or manage a conflict or resolve a conflict by helping them to develop mutually acceptable agreement. So when it comes to mutually acceptable agreement, we are talking about agreement that both parties have agreed and accepted. Right. So moving on, And in 2018, as the word was more into arbitration, which is similar to the core system. So a lot of cross-border issues were being resolved through arbitration. So based on that, in 2018, Singapore led with the drafting of new convention for arbitration, for mediation, sorry. You know, as far back as 1958, there has been a convention. Even as far back as 1922, 23, there were talks and there were conventions governing cross-border arbitration or arbitration between people who are trading among ourselves from different continents, and the enforcement of the award, so that this were discussion around. But mediation was left behind, and there were no discussions until around 1970s, where the UNCTAD also started developing mediation guidelines for countries to use. But in 2018, a group of committees together with UNCTAD and Singapore leading the charge also led to the passage or the adoption of the UN resolution on it is called United Nations Convention on Settlement Agreement resulting from mediation. United Nations Agreement and Settlement, United Nations Convention on Settlement Agreement resulting from mediation. So now we have a convention which is for mediation. Ghana signed July 2022, and we are yet to rectify by Parliament. So it is not in force in Ghana. We have signed, but it has not been rectified. But a lot of countries have signed and they have rectified them. So the Singapore Convention, which is now International Convention for Mediation, in a very broad manner defines mediation as a process, irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third party or persons lacking the authority to impose a solution upon the parties to the dispute. So, by this definition, it means that if you have anyone who is assisting parties to resolve their issue, but the person lacks the authority to impose a decision on the parties, but the parties are left to make their own decision, then that process is called mediation. So that is by the Singapore Convention. So that is the understanding that you have to get here. Then moving on, so there are types of mediation. One is facilitative mediation. It is where parties are encouraged to negotiate based upon their needs and interests instead of their strict legal rights. We have settlement mediation, where parties are encouraged to compromise in order to settle the dispute between them. We have talked about compromise yesterday. Yes, then we have transformative mediation, that where parties are encouraged to deal with the underlying causes of their problems with a view to repairing their relationship as the basis for settlement. You know that there are certain issues that will be happening. If you are not able to deal with the underlying, the iceberg which is hidden, if you are not able to deal with that, the upper part will still be there. So this relationship, if you are able to know, go to the root cause and know what is happening and deal with that situation, that serve as a basis for the resolution of the other party. So that is transformative mediation. Then we have evaluative mediation. Evaluative is where parties are encouraged to reach settlement according to their legal rights and entitlement within the anticipated range of court remedies. So if you are saying that if you go to court, the court, this is the amount you are seeking maybe $2 million. The same way, when we sit on mediation, can we get the $2 million? If we can get that and agree on the $2 million, why do we have to waste our time again and go to court? So within the court remedies, I could have gotten this, but through mediation, I think we can do this. These are matters that mediators can help parties to do. Then we look at authority of the mediator. Does a mediator have any authority? So this is, you do not have authority to impose decision. Your authority is residing, so mediator's authority reside in his or her personal credibility. So the authority you have is the credibility you have, trustworthiness, expertise in enhancing the negotiation process, experience in handling similar issues, and ability to bring parties together on the basis of their own interests, past performance, or reputation as a resource person, and in some cultures, his or her relationship with the parties. So this is your authority, and you ask yourself, this is not an authority, but in mediation, this is the authority that the mediation have. If you have credibility, if you are able to be trustworthy, that is the authority that you have, because people will be able to trust you and you can assist them to resolve their matter. So authority or recognition of the right to influence the outcome of a dispute is granted by the parties themselves rather than by an external law, contract, or agency. So for mediator being able to assess parties or to influence an outcome of a process will be dependent on the parties, not by any external law, because no law permits mediator to impose a decision on the parties. It is by a decision made by the parties' own volition. It is only when the parties ask you, Mr. Mediator or Madam Mediator, at this point, what do you think we should do? The mediator can suggest, but be careful you don't fall into the pit, because the fact that you can suggest doesn't mean that you should tell them what to do. So instead of maybe suggesting, you instead of telling them what to do, you put it in a suggestive way, or in a question form, in an open question format, where you can ask them, have you looked at it from this point? What about this? Have you considered this? So that they themselves will now accept and look at it from that perspective, without they saying that you are the one who imposed a decision on them. Because I have encountered such before, where we resolve an issue for a woman. She went and called that the the mediator asked them to do A, B, C. And I said, isn't the mediator who asked you to do that? She said yes. And when she went home, she still doesn't think that that is a fair deal. So I said, okay, come back, we'll call the other party. We brought them back, and they brought the mediator back to explain what she told me on the phone. And she said, no, it was the influence that she had when she got home. She didn't understand the thing well. But now she has understood the process, and that ends the matter. These are some of the things. So in order not to encounter such challenge, when we are training, we also let you know that this is what can happen. So in everything that you do, don't make it like you are the one telling them what to do, but they themselves being able to identify what they want to do and do them properly. So there are skills that you, the mediator, must possess. This morning we are talking about techniques in handling mediation. So to be able to effectively deploy your techniques, you must have skills needed for that process. So that notwithstanding, there are certain fundamental principles and core skills associated with being a mediator. Among the common features of mediation are the following points. Neutrality of the mediator. So aside being credible, aside being trustworthiness, there is a need for you as a mediator to be neutral. So your neutrality must not be questioned at all. So the neutrality and the impartiality of the mediator are of fundamental importance to this process. So for any mediation to be successful, the mediator must be seen as independent. So then authority of the mediator has no authority to impose a settlement on the parties or the disputants. So you should have this at the back of your mind. So the mediator is only a facilitator of the process, whose primary role is to assist the disputants to settle their differences through a negotiated agreement. Mediation involves some element of facilitation and assistance so that the disputants can negotiate with one another. And that is what you, the mediator, must understand. So consensual resolution, you must know that the resolution must be consensual. Nobody should be pressured. Nobody should be forced under duress to sign any document in the mediation process. So consensual resolution, mediation is consensual. So the only binding outcome of the mediation is the one with which all the parties agree. And this is what a fundamental point that you must remember, that an outcome of mediation should be the one parties have agreed upon and nothing else. So maximization of interest. The objective of mediated settlement, unlike an adversarial trial, is to maximize the interest of all parties. So as you are advancing the process to support the parties to resolve, your role is to make sure that you maximize the interest so that each party, it will be both gain approach. If it is both gain, we are not saying everyone will get 100% each, but we are saying that if it is both gain, parties can get 1% out of 100, but that will be fair to him, and that the parties will be okay. Then provision of a secured environment. You see the certain position. In mediation, the parties must feel safe. They must feel, and sometimes if it involves high level or high stake mediation, security personnel may be involved. I remember we resolved an issue between a mining company and the community, and it was high level mediation. So anytime that we go, we are accompanied by security. The national security will also be there, and the other security apparatus will be sitting even within the people, so that in the event of anything, they can alert us. So these are some of the things that you need to do. As your Humphrey was explaining yesterday, that someone recorded it and he didn't understand. He just informed the people that this is what has happened, and it nearly ended into something else, which the security agencies was telling them that why didn't you inform us? So in high level, high stake mediations, sometimes you involve the security so that everyone will know that they have a secured environment. No one will abuse them, or no one will take advantage of them. And if it is one-on-one mediation, that is where the mediator always sits in the middle, so that in the event one person gets angry and they want to throw a punch, the other side can also deflect or catch the blow. These are things to make sure that the parties sitting on the table feel safe, and they don't feel intimidated. So it is the mediator's responsibility to create conditions which are conducive to discussions and the exploration of settlement options and possibilities. This applies not only to the physical arrangement and ambience, but also to the ground rules regulating the process. So in providing secure environment, not only about the physical ambience that you have make sure that everyone is safe, but also ground rules to govern the process so that people will not use abusive languages on the other party. So you'll have to let them know that the mediation process will be devoid of any vulgar words, any harsh words, and that everyone will have the opportunity to express themselves and talk, and know when one is talking, no interruption. You give them paper that if that party is talking and you feel like writing, you put it on the paper. And this helps to create safe environment for all parties to be able to express themselves and be able to offer their what they think is a better solution. Then offer of confidentiality. So mediation is by its very nature a private and confidential process. So the mediator must first offer confidentiality to the parties who may also agree to a mutual confidentiality. So you, the mediator, you must let them know. So as a way of confidentiality, as a mediator, I am bound by law not to disclose anything that you share with me here. I might also the same way request that you also do same, and it will be part of the agreement that you sign, which is the consent to mediate, that will signify that whatever that is shared here will not be devoid to another person. Somebody may come or may be there, they may want to tell the husband, yes, there are information that you can tell, not other things that you can tell. If it is a high stake or community-based mediation where the people are many and the parties are being represented by leaders, at the end of the process, you must agree that today we agreed on this, today we did this, today we did that. And for that matter, this is what we are going to communicate to the external people, so that the people will know what is happening in the mediation, so that at the end of the process, and this is what sometimes especially our prominent leaders who sometimes do mediation fail to do. Because if at the end of the process, the parties have agreed on a joint statement, they would have come and read that statement to the public or to their people, so that that becomes the statement that have been agreed upon from the mediation, so that even if another person go and share another document, the public will know that this is what the parties themselves, the two of them, they came and they read it out to the public, and this is what will help the process. Because if you don't do that, everyone will go out and be telling whatever that they want to say to the public. These are some of the things that even our people must be aware and agreeing on how communication is done during the mediation processes, especially with high level cases. So then, inability to offer independent advice, because in mediation, the parties are responsible for their own decision. A mediator is not supposed to offer advice to the parties. So as a mediator, you don't offer advice. So if you want to do anything, it should be a form of open-ended question or suggestion that the parties can accept or reject, but not to say that I think. Instead of saying I think, you could have said that, what about this? Have you looked at this? What have you considered this? Would you like to look at it from this perspective? So that the parties themselves will say that, oh, okay, we didn't know about this. Tell us more, do this. And that will help them to understand these processes. So the mediator can only ask open questions. Right. So that is an overview about what skills and other things, topping up of what our brother Humphrey discussed with you yesterday. Now let's come to the mediation process and strategies. So the strategies that you are supposed to employ. So step-by-step process. So the mediation process is a practical step-by-step procedure. But before that, let me pause here and ask, are there any questions up to this point, please? Any question up to this point, please?
No, please.
Okay, no from your end. Any other person?
So, okay, thank you very much for the skills. From my understanding, it means most of the mediator skills need to actually come from the trust and credibility the parties have. Should one of the parties, the parties at any point say they are no longer, they don't trust you as the mediator, will you recuse yourself from it and then also suggest someone?
Perfect. So it happens in different ways. For instance, the mediation starts with the parties appointing the mediator or who appointed the mediator. So that is where sometimes the question is, who appointed the mediator? In actual mediation format, the parties must appoint the mediator. And if someone appoint the mediator for them, they must agree to the candidature of the mediator. So once the parties agree, it means that they accept the person who is going to do the mediation. But in the course of the mediation process, the parties can raise an eyebrow and say that we do not trust the mediator again, and we think that the mediator should recuse himself from the process. The mediator must do so because the parties are not the one. You are not the one to make the decision for them as the mediator. And for that, if they are complaining that you, the mediator, should recuse yourself, you should be able to do that. And sometimes you must find out why they think that you must recuse yourself. Maybe it could be as a result of misinformation or sometimes lack of information about certain things. So find out from them, engage them. But sometimes the mediators may take hostile behavior and say that, why do these people behaving like that? But know that the case is not your case. It is for the parties. And if parties are raising issues that you, the mediator, there is something that they don't understand about you, engage them. And if after the engagement and you realize that what they are saying and will affect the ultimate outcome of the process, recuse yourself as a mediator. Just tell them that yes, at this point you thank them for trusting you to do the process, and for that matter, you want to recuse yourself, and you exit the mediation process. Or even sometimes, not even the parties telling you, the mediator, if you realize that the stakes are high and things are not better, the mediator can also recuse yourself. Tell them that yes, you have seen that continuing with mediation process will not be worthwhile, and for that matter, you want to stop the mediation so that they can look for another person if they still want to continue the mediation, or use another forum for another process. These are the things that a mediator can do. But the difficulty sometimes we have with high stakeholder or high stake conflict, especially in Ghana, is that the mediator may be a prominent chief, and even whether allegation is made or not, they still want to finish the process. They don't care about what is happening because maybe the president appointed them. Somebody gave them that authority to go and do. But we should understand that if we are doing mediation, mediation must thrive on the consent of the parties. And if the parties raises any issue, we should be able to address them. And if we address them and still there is no um, possible area of agreement, the mediator should be willing at all times to recuse themselves so that another person that the parties want, so you don't even suggest anybody for them, you leave peacefully. They themselves must look for another person to assist them to resolve their matter. And that I hope I've answered your question.
Yes, sir, you have. Just to add again that at this high level stakeholder mediation, I don't know, with the presence of the security, does that not pose as an intimidating force to the parties to freely discuss?
No, depending on the way you explain it to the parties. So, for instance, if one party is afraid that the other group may get them there or may attack them, then you make those arrangements for the security present. Or sometimes in a subtle way, they may not even know that they are security. So they may be officers who are wearing normal mufti like the way you, the mediator, have also dressed. Some of them may even join your team. So sometimes if this you are doing co-mediation with others, you may introduce them as mediators. The parties may not know that they are security people, where if something is about to happen, these people may get to know that, okay, no, these are high stake, this is not good. Or sometimes you can introduce them as some of your handlers who are helping you to do the mediation. So depending on the nature of the issue, if you think that these are matters, if you introduce the presence of police and military, the people will be afraid, then you can think of producing or providing security with those that may not wear military or police uniform, so that they will now be in to get intelligence as to what is happening, so that in the event of anything, they can call for backup and immediately things can be solved. I hope that is okay.
Yes, sir. Thanks very much.
Okay, great. Okay, so if there are no other questions again, now let's go on to the steps by steps processes. So mediation, as discussed yesterday, we are taking it further. It's a step-by-step process, and it's a practical step-by-step procedure that helps people in conflict to understand, explore, develop solution to disagreement or dispute, and it is a map for this resolution, as mentioned by Humphrey yesterday, if you remember. It is a map for resolution. So mediation is a structured process. So it's a map. So if you are going from Accra to Togo, Accra to Kenya, Accra to Zambia, all the airlines, they use map. They navigate. Where do we pass? We pass here, we pass here, and we are going to get here. So the same way, a mediator must also have their map for resolution. In mediation, we call it a checklist. When you are those who fly planes, they also have their checklist. So because they do their checklist before the plane takes off. The same way, we must also have our checklist as mediators, a plan to assist us to do the mediation. right? So the mediation process involves a preparation time before the parties meet, and then 5 steps where people involved in the conflict work together. So some books may call it 7 steps, some may call it, some don't add caucusing as a step, they add it to the process. Some may add caucusing as a step, so we make it 6, and some of them add the 2 preparations, so it makes it 7. So depending on how you do it, you can make it 5, you can make it 6, dependent. But the most important thing is that you being able to run the process to get the people talking and to find the solution to the problem, right? So the process involves preparation time. So you, the mediator, you prepare to meet the party. So if it is high stake mediation, you have to make sure that you do a background, you do analysis about the parties and their background, what to even wear on that day, how to appear there, and for people not to assume that you belong to the other side. It's very important. But when you get to the two interpersonal, the two-party mediation, that one you don't have much to do, because sometimes even the parties will narrate the issue before you, and you begin to ask questions to understand it better. But on a high level mediation process, you may have the facts. Sometimes the security agencies are even involved, where they have even briefed you, they have informed you, they have given you certain information about the issues. You have to ask questions, clarify, so that you know how you enter the situation. So you, the mediator, will learn about the subject area. What are the issues? What are they fighting over? What are the things? The question that when you go, you can ask how you conduct yourself in order not for somebody to believe that you are being biased as a mediator. These are some of the things that you must take into consideration, right? So moving on, preparation time. So preparation to thoroughly understand the issue before the mediation session. So you as a mediating must understand the issues. But if I'm saying that one-on-one or commercial, some of the issues you may not understand before you get there. Sometimes once they speak, you get to understand them. But when it comes to a comprehensive matters, or sometimes you may have the information beforehand. So when you are go, you thoroughly understand the issues before mediation session. Gather comprehensive information about the parties involved, their concerns, and the underlying issues that they are having issues with. And so establish a clear goal. You, the mediator, what is your goal? Your goal is to allow the parties to be able to communicate. So that should be your role. Your role as a mediator is to allow the parties to be able to communicate, because the answers, the solutions will come through the communication, because once they are communicating, issues are being cleared and people are now getting the perspective of the other party. So your goal as a mediator is to go there to make sure that there is a level playing platform where each party will be able to express themselves without fear, and the other party will also be able to do same, so that at the end of the day, there will be mutual understanding. So understanding is built first. Once there is understanding of the issues, parties will now know what solution will be best fit for that issue. And sometimes too, once the people have been able to understand the issue, now the focus should be on the issue now. So removing the people from focusing on each other as parties and now focusing on the problem at hand, so that the matter can now be dealt with without fear or favor from any other side. These are some of the things that you, the mediator, must focus on and set clear goals to that perspective. So select an appropriate technique. So what techniques, how am I going to go about this issue? When I go there, what am I going to say? What am I going to do? Your techniques, your communication techniques, with the word, the choice of words. There are certain people, maybe they may not like the use of certain words. You must understand these things. And sometimes the matters also come as a way of distributive. When we are talking about distributive, it means that the parties that are involved are more aggressive in nature, and their mindset is only on either they win or they lose. So if you are meeting parties like that, how do you help them to move them from that line into an integrative conversation where everybody will be thinking about win-win? If I get some the other party gets some, it is good. So these are some of the things in order to collaboration, moving from being self-centered to a more collaborative way. So you come to the opening statement. This is one of the way you, the mediator, will welcome them. So if you look at the video, using the video as an example. So the mediator welcomes them. So the first formal part of the mediation comprises an opening statement by the mediator. Welcome. My name is Isaac. I work with the African Center for Collaborative Dispute Resolution. I am happy that you have selected me to be your mediator, and I hope today you'll be able to get solution to the problem that you brought here through the discussion that we're going to have. May I know your names? They also mention their names. So this helps you to build rapport with the parties. It put them at ease. So the experience indicate that this is an important stage of the process, particularly for first-timer clients of mediation, regardless of how much prior contact there has been with the mediator. It doesn't matter what some of them, when you call them on phone to even inform them about the matter, they wanted to even explain. You had some talks with them, we had discussions with them, but when they come, when the two of them are sitting behind in front of you, this is your opportunity to make sure that you build a good rapport with them. So as we always say that first impression counts. So let it count at this stage. The way you welcome them is very important. So it helps also to set the tone. So set the tone, you set the tone. So you create a neutral and respectful environment to encourage open communication. So if they will come and the mediator is someone who is not even laughing, or he's serious. They come and your head is on your table and you are just writing. Yes, welcome. Then you are not even looking at them. They don't see an environment for open communication. Then establish ground rules. So you are going to establish what you call ground rules for the first mediation process, ensuring a structured and a fair discussion. So the ground rules are normally captured on a document that we call the consent to mediate, or you can prepare your own ground rules that, depending on the nature of the issue, you can discuss with the parties. So let me show you a sample of ground rules that you can have. Okay, I hope you can see the screen. So you see African Center for Collaborative Dispute Resolution ground rules for mediation session. So we, the undersigned, hereby voluntarily agree to participate in the mediation session facilitated by the mediator from the African Center for Collaborative Dispute Resolution, AfCCoDR. We undertake that mediation is voluntary and confidential process and aim at resolving dispute amicably. We willingly commit to engaging. So this is your ground rule. All this information here is captured on what we call consent to mediate, where the parties will sign. But your ground, this is what you use to explain to the parties. So you find out from them that yes, did you agree that the mediation center should be AfCCoDR? They will tell you yes. So AfCCoDR will serve as our mediation center to facilitate the mediation. Is that what you have agreed? Did you agree to the appointment of Isaac Asari as the mediator from AfCCoDR to who will serve as your mediator? They said yes. Then we count voluntary participation. Do you acknowledge that your participation in this mediation session is entirely voluntary, and you have not been coerced or compelled to attend? They will tell you yes or no. Right to withdraw. We understand you have right to withdraw and to withdraw from the mediation process at any time without prejudice. But we want to encourage that if you don't understand something, you don't just walk away, but you find explanation to that. So confidentiality, do you agree to maintain confidentiality of all discussion documents and information shared during the mediation session? So this is a sample that I wanted to show you. But this one will also be transferred to a form which is called consent to mediate, which I will show you as we move on. So let's go back to the presentation. Yes, so having established the ground rules, so the opening statement from the mediator will help you to establish the ground rules. So once you establish the ground rules, then so functions of your opening statement, the opening statement that you are making, it has a function. It has a function. So there is a function from your ground rules. So your ground rules play a major function. So your ground rules play a major function. And what is the function? So it allows the parties, to settle in and put them at ease, as their role is limited to listening, and provides a mini mediation ritual. So this is like you have entered a shrine where you don't know anything. The priest is talking and doing some incantation. And that is what you do as a mediator. People have entered your shrine, that is your mediation room, and you are doing incantation. You welcome them. Yes, like the shrine, the priest will welcome you. Yes, my children, welcome. This is Nana, this and this and this and this. All your problems, then they will start doing some certain things. These are the same way when you come to the mediation, just doing that as an example. When it comes to mediation, you are doing this for the parties to be able to settle in and build rapport with them. So their point at this stage is just listening. So welcome, my name is this, this, that. These are ways to build rapport between the parties and the mediator. Reassure the parties on their choice of mediation, if relevant, and commend them. So I must commend you for choosing mediation to resolve your matter. I must say that we have used mediation to assist a lot of people to resolve their issues. And I believe not to promise, but I believe that with your issue, mediation will be helpful for you to have an amicable solution. Acknowledge the significance of the matter to all parties. I must acknowledge that this is very important matter to all of you, and it must have been a difficult situation for all of you to this point. And I believe today you can have room for a lot of discussion. Then inform them about the nature of mediation. So the mediator's role and their role. So by way of education, mediation is a structured conversation where me as the mediator that you have appointed will help you to communicate with each other through my facilitative role, and for you to also do the discussion. So my role as the mediator is to help you to communicate, to make sure that I'm like a moderator of the process where I'll guide when each party will speak. I'll ask to certain questions for clarification. Your role is to speak and agree on any points, as many as you can. So that is your role, and that is my role as the mediator. Then it can be used to distinguish between mediation from other forms of intervention like counseling and arbitration. So by way of education, mediation is not like arbitration where the arbitrator has the power to decide for the parties. Mediation is a party autonomy process. When we say party autonomy process, it means that parties are the one who do the decision making. I am here to support you to make the decision, any decision that you can make. Right. Then explain the order of event for the rest of the mediation session. So by way of order of event, let me share with you that the mediation process, this is the first stage where I am preparing you for the process, which is also means that I am giving my opening statement. At the next stage, where we call it storytelling or uncovering stage, where you will be given the platform to share your side of the issue. This your sharing your side does not mean a reply or a banter of what the other party has said, but to also see your side of the issue and be able to understand your perspective. So then we'll go into another stage where we are now going to search for options, generate as options as we can, which will help us to get possible solutions that will help you to bring closure to this matter. So I hope you understand. Then, so let me emphasize again that mediation is flexible process. And for that matter, if at any stage that any one of you wants to go use the restroom, please you're allowed to do so. The restroom is just here at the corner. If you want to have water, there is water on the table. There's a coffee machine there. If there's a point that you need a coffee, you can take some. There are toffees on the table. I encourage that everyone put their phone on silent. And let me also emphasize again that this is done without prejudice, and no recording shall be done here and taken out. So please, since I know, since you are business executives, I presume that you may have calls that people may need you. So you can put your phone on silence. If the need be, you excuse us and receive your call and come back. At that point, we'll pause for you to finish the call and come back. And let me also emphasize again that at the point where if any of you have some medical engagement, or you have medication that you have to take at a certain point, please feel free, and there will be time for you to do that. When it is time, just prompt us and you can do that. So that is how flexible mediation process is. So stresses the flexibility in the process. Then explain the rationale for the party statement and provide an order for the presentation. So you are going to tell us your side of the issue, and it is important that I understand your side while the other party also understand each side. So establish the mediator's control and the party's commitment to the mediation guidelines and table manners for the mediation. So a way of agreement, when one is talking, there will be no interruption. These are books or writing part. If someone is saying something that you want something to say about or want to banter, please do write them. When they finish, immediately they finish, just raise your hand. I'll give you the opportunity to also share your side of the issue. I hope we understood. They say yes. Allow the mediator to establish his or her credential. By way of my background, I am a mediator with over a decade of experience. Let me say I am between 12 and 13 years of practice now. So I have been able to resolve a lot of issues, and I've resolved similar issues of the ones that you have brought here. And once I share that every mediation or every issue is unique, I have considerable knowledge about what is about to happen. And I believe that through this process, you'll be able to have a good result. So trust the process, and you will have a good result for yourself. So that's by way. So you tell them about a little bit about your background, that is your credential. Then establish positive goal and optimistic tone for the proceedings. So I know that this must have been a difficult situation for you, but I have seen cases of this nature, or even difficult situation more than this, where mediation has been able to resolve such matters. And I believe yours is not different, and I believe you can get a better solution from here today. Then identify common grounds and common goal. Encourage parties to actively participate and remind them that they are in control of the outcome. Deal with confidentiality issue. Let parties know that they are in control of the outcome. Then deal with the confidentiality issue. If you are in Ghana, you can refer them to the Ghanaian law, which is section 78, which is disclosure of information. 79 talks about confidentiality. So by way of confidentiality, I'll crave your indulgence and I'll read section 78 and 79. Section 78 talks about disclosure of information. Then 79 talks about confidentiality. Since I am reading, I am not going to interpret the law, but I'm reading as the law states. So please take a listen to it. So you read the law to them. And this is what the law say about confidentiality. And I hope you will respect the provisions of the law. Then confirm the mediator's neutrality. So I want to also emphasize again that mediation is not a way the mediator will decide for the parties. The mediator does not decide. So as you are sharing your perspective, none of you should try to convince me to understand your perspective better or do anything to sway me to your side, because I do not make decision and I am neutral, I am impartial, and I always stand in the middle to make sure that the two of you have a solution that works for you. So you establish your neutrality and impartiality. Establish the parties have authority to settle if relevant. So by way, before we go on, I want to find out whether there is an authority that you need before we get going, or you have authority to settle. So you find out. So the parties will tell you whether they have authority to settle or they don't have. Particularly if it is a family issue and you have the abusuapani there, you know that if it is a rightful abusuapani, then it means he has authority to settle. If it is a company and you have the branch manager or the general manager or the directors there, and you know that they have authority to settle. But in the event where they send an officer from the organization, they must give them an authority letter that they have the right to come to the mediation, sit and make decision that will affect the company. So that at the end of the day, if they agree, they don't tell you that we have made this draft, we have to go back to our company before we can agree, which can also serve as another header. So if they can take a decision to a certain point, they must tell you that the company brings you a notice and indicate that yes, these people are going here, these people are coming for the mediation, and that they have this power to take the decision up to this point. Any decision that is beyond this, they have to report back to us. So establish that first, especially commercial matters where companies are involved. If not, they will say that they didn't have authority to even attend the mediation and that we don't accept the liability that they have brought. So you have to be careful on that. Classify or clarify special conditions, for example, on the need for agreement to be reduced in writing. So you have to let them know that at the end of the day, whatever, if we get an outcome, the outcome will be reduced into writing. So it will be into writing, and then it will be reduced into writing. Then address any other formalities regarding settlement, for example, review or ratification that might be required. So depending on the jurisdiction, if it is private mediation and the parties finish mediation and they agree to the terms and they perform the term that they have made, the mediation ends there. It doesn't go anywhere again. Unless one party breaches it, then the other party will take it up to court for enforcement, for adoption and enforcement. But if it is a mediation that the court refers, then it means that it will go back to the court for adoption as consent judgment. The court will adopt it as consent judgment. So if it is court annexed mediation and the case is referred to you, when you finish, you report back to the court that the mediation has been completed, and then this is the outcome, so that the court will now look at the outcome and adopts it as their outcome. Then manage expectation. So don't just be promising them. Don't go and be promising the parties. Don't be promising them. Let them understand that yes, mediation is good. Mediation is good. Will give them all the necessary, but let them know that in some there may be impasses, there may be difficult situation, there may be difficult moments that they have to deal with that situation. So manage expectation, for example, by reminding the parties that they might reach impasse, they might reach difficult situation that compromise will be required. So one thing about mediation is that you may get to a place where the discussion may not be a little bit friendlier. I encourage you that when we get to that stage, stick to the process, trust the process, and I believe we can have a better outcome. Encourage openness and information exchange. So let them understand that they need to open up and share information with each other. Allow for clarification on the role of the lawyers, witnesses, and other support parties present, and those who may be at the end of the telephone. So sometimes you may be doing online mediation and people may be talking. We have to let them know that the people who are behind are not part of the process, and that only those who are in the room, and even if they brought witnesses, sometimes you don't even allow the witnesses to go inside the room. It depends on the nature of the issue. Sometimes you can allow, or sometimes you may not. But one thing that I have to let you know that if lawyers want to come with them, allow the lawyers to come, and when the lawyers come, acknowledge them, their presence. Oh, councils, thank you for joining your parties. Oh, when I see councils who have devoted their time to support their parties like this, oh, I feel happy and excited that councils are taking interest in mediation to support their parties, and I must commend you. However, in this mediation, we'll be happy if the parties are allowed to talk themselves and for them to be able to bring out issues that confront them, issues that affect them, so that in that way we can now understand them better. So I will be happy if the lawyers will be supporting the parties in that regard. So you play the supporting role where the parties will now be talking. So we are now going to change the courtroom a bit, where in the courtroom where you used to talk, now over here, the parties are now going to talk. So I hope it is understandable by the lawyers. Then the lawyers will say yes or no. So you get that. So in almost all cases, the statement is presented orally. So this one that we are doing is presented orally. And in some cases, points are distributed in written form or shown on the overhead projector, which parties can follow as the mediator works through the terms and through them in a more detail. So you can make it a PowerPoint, or you can make it a point that you share with the parties, or you can make it oral. But one thing is that depending on if it is multi-stakeholder mediation, make sure that you have the points projected on a projector so that you explain. So at the end of the day, they can ask their questions and everybody will be on the same platform. So I remember last week or so, last 2 weeks, I think last 2 weeks, we did a preliminary meeting for parties who are coming for arbitration. So we were supposed to do it online. So what I did was that I shared the I did a PowerPoint on the processes that we're going to take them through. So when they come after the introduction, I told them that yes, I put the process in the PowerPoint. So I'm going to project it, then we go through step by step, step by step, step by step. So it makes the things easier and more professional. So you can also try similar things. So now let's look at the samples. Yes. So preliminary meeting and preliminaries. Welcome and introduction. Welcome to the mediation. My name is Isaac Asari, and I'm going to be your mediator. So who can also say it in a different way? Now, I want to hear you. So like I explained, so preliminary, they have come, your opening statement. Welcome to the mediation session. My name is Isaac Asari, and I'm going to be your mediator. Looking at this and what you saw in the video, what can you also say? So I want to hear you. Now I've been talking, so let's go. Everybody should write their own in the next 1 minute. Write your own, and you read it to us. Write your own in the next 1 minute. Let's go. Okay, so now let me hear you. Who is ready? Or let me start mentioning names. Okay, Gloria, let me hear yours.
Haven't yet finished. Yes. Maybe I would say welcome to this mediation session. Thank you for choosing mediation. My name is Gloria Hingoma, and I'm going to be your mediator for this session.
Okay, great.
And, yes, thank you.
Okay, thank you. Kanye, let me hear you. Okay.
Hello, good morning. Good morning, everyone. My name is Kanye Abusa, and I will be serving as your mediator today.
Okay, great. Let's go to the next one. Reverend Dr. Gillian.
Hello, you are welcome to the mediation session. I'm Reverend Dr. Gilliam Sabelia. Comfort yourself at any sitting place.
Okay. Next person, let me see. Veronica. Hello, Madam Vero, are you there? Okay, let me go to Mr. Yenchi. Hello, Mr. Yenchi, are you there? Okay, let me go to Christine.
Hello, welcome to the mediation session. I'm in the person of Christine Balu, and I'm going to be your mediator for this session. Thank you.
Okay. Okay, great. So thank you all. Also, so that is how we do it. So this is the first step. So welcome and into that. So welcome. So okay, Mr. Yenchi is ready. Let's hear you.
So hello, people of hope. You are warmly welcome to today's mediation session. I am Kwesi Renchi Boateng, the mediator. Thank you for choosing mediation. Feel free, feel relaxed, and let's walk through this exercise together. Thank you.
Okay, thank you. Okay, so this is a mediation where lawyers were involved. So you see, welcome to the mediation session. My name is Isaac Asari, and I am going to be your mediator. You both know each other, but you may not know each other's solicitor. Engineer says, this is Dorothy, who is assisting Elizabeth. Elizabeth, this is Samuel Asamoah, who is said solicitor. Please call me Isaac. Are you also comfortable with first names? So this one, the mediator did not allow them to introduce themselves one by one, but the mediator introduced himself because he knows the parties, and he also introduced the solicitors, and at the same time find out from the parties whether they are comfortable with first names. So now this is the first aspect. So now rewrite this on how you want to do it without the mediator introducing the party, but the parties introducing them. In the next 1 minute, kindly rewrite them.
Sorry, I didn't get you very well.
Have you seen what is on the screen? Hello, Kanye. Are you here? Yes.
Yeah,
So
okay,
I'm
okay.
saying that what is on the screen, the mediator
Yeah.
introduced all the parties by himself. At this point, the parties were not the one who introduced themselves. So
Okay.
what can you do differently aside what this mediator did? So you can rewrite it
Okay.
in a different way.
Okay.
Yes.
Okay.
So 1 minute, everyone is supposed to write. 1 minute, 1 minute. So we have 30 seconds. Okay, who is ready? Let's go. The 1 minute is over. Or I should start mentioning names again. Okay. Mr. Yenchi, you went last, so you are going first. Let me hear you.
Okay. Thank you. You are warmly welcome to today's mediation session. I'm Kwesi Chibwat.
Hello? I thought my
Comfortable,
net.
let's say,
Okay.
Kweku. Are you comfortable if I use your first name, Kweku? Okay. Well, you can also call me Kwesi. And then maybe Ajwa. Thank you.
Okay, thank you. Last person. Okay. Reverend Dr. Gillian. Hello, Reverend.
Hello, Council. You are welcome to today's mediation. I'm Reverend Dr. Gillian. And you meet Madam Juliet, who is assisting Kofi in today's meeting. You also meet Auntie Amma, and you can call her Auntie for short. Thank you, Council members.
Okay, next person. Gloria.
Yes, welcome to the mediation session. My name is Gloria Hingoma, and I'm going to be your mediator. You may call me Gloria. Assisting me, I have two assistants in this session. They may introduce themselves. And how would want you to be called. That is after the others introduce themselves. Then we have the two parties. You may introduce yourself and inform us how you'd want to be called. Thank you.
Okay, thank you. Kani?
Okay. Hello, everyone. My name is Kanye Abu Safuli, and serving as your mediator today. I'm pleased to be here to assist you in working through your issues. Feel free to introduce yourself and tell us how you'd like to be addressed in our session today. Please call me Kanye.
Okay, great. Thank you. Christine?
Okay, so welcome to the mediation. I'm in the person of Christine, and I'm going to be your mediator for this session. Would like us to have a little introduction for us to be able to know each other, for the convenience of it, for us to be able to interact easily. And I'll prefer to be referred on my first name base, which is Christine. I'll give you my parties the opportunity to introduce themselves. Thank you.
Okay, so thank you all. Well done. But the few things that we have to note that
Hello.
our focus. Hello?
Please, can I go on?
Yes, please do.
Okay. So you are welcome to ACCoD Mediation Center. I'm Veronica Bannerman Williams, your mediator for today. With me is Vera Addo, my co-mediator. May I know how you want me to address you? Thank you.
Okay, thank you. Okay, so thank you for the wonderful job. You'll be good mediators. So one thing you have to note is that the focus is not on the councils. Somebody mentioned that councils, you are welcome. The councils are not the focus for the mediation, it's the parties. So we are focusing on the parties. So, or you don't even mention councils of parties. So welcome, you introduce yourself. So for instance, I could have done it in a different way. Welcome, my name is Isaac Asari, and I am glad that you have appointed me to serve as your mediator. Please, may you introduce yourselves and your team so that we get to know each other for the purpose of this discussion. And for easy discussion, you can call me Isaac. And please, you can go ahead with the introduction. Then they will introduce themselves. So if they introduce themselves, then you thank them. Thank you. Please, are you also comfortable with the use of your first name for this discussion? They will say yes or they may say no. Then you proceed from there. Then again, with somebody also mentioned that I'm going to have two assistants. The two assistants, what are they? Who are they? Are they mediators or who are they? So if they are mediators, you don't call them assistants unless maybe they are there to observe the mediation process. So you just let them know that I have two people here who are going to be observers, or they are going to take note for me, or they are observers who are also learning to become good mediators, so they are observing the mediation process. So you let the parties know. And these people are going to observe all the confidentiality in the process. If they are co-mediators, you don't tell them that they are helpers or they are my assistant. If you tell parties that this person is your assistant, it means that whoever or whatever that they say, they will not be in support of that. Even if they suggest anything, they will not be in support. If they sometimes they may ask them even questions, then they may not even answer, because they know that the mediation, the head of mediation has not spoken, and that they will be referring to you rather than the other people who may also bring in intervention that will be helpful. So you let them know that this is my co-mediator. So, and with me is my co-mediator. So I'll give them my colleague the opportunity to also introduce himself, and after that you take it from there. And you and the co-mediator will come to that where you have to share the introduction, where one has to come in, where one has to be in, where the other has to be. This helps in making sure that you are not running one-sided mediation process. So that is the first aspect of the your opening statement. So, and it will go on. So let's move on. You see other things that the mediator will also add. So the mediator wants to check in with them, time constraints and settlement authority. So before we get going, I would like to check with you your timing matters. Originally, as I've been discussing with you on the phone, we agreed to meet today for up to 4 hours. Can you recommit to that? Then the party will say yes or otherwise. Then, do you have any parking limits or any time constraints? They will say no, or we can do the 4 hours. Do you both have authority to resolve this matter today? Then, especially when they are representing somewhere or company or organization, then they will tell you yes or otherwise. Then you take that into consideration. Then here is very important: extent of prior contact with the parties. It is very essential in mediation. So, by way of background, Elizabeth, you approached me about having a mediation, and I spent some time talking to you on the phone and sent you some written information about mediation and said I did same with you. You both know that I have spoken to your solicitors by telephone and have received the papers which you have prepared for me. That is all the contact I've had about this matter, and I've had about the same access to both of you. Hey, are there any questions about that? You find out from them, and they will tell you yes or no. Then, nature of mediation and the role of the mediator. You have made a decision to come to mediation yourself, and generally, this is a better way of dealing with problems than going into battle. So that is a commendable start. Let me tell you briefly a few things about mediation, although I appreciate that you may have heard some of this before. Mediation is a structured opportunity for those with a problem to make decisions about it themselves. My role as the mediator is not to make those decisions for you, nor is to tell you what decision to make or to advise you on law or on technical matters. My role is to assist you along the way in your own decision making. Sometimes emotions or poor communication makes it difficult for people to deal with problems. The mediator's role is to guide them down the path of decision making and help them to avoid the obstacle and pitfall. Elizabeth then said, you will be discussing the situation and making the decision, and your advisors will assist you in that process. Any question about that, they will say. Then experience and credibility as a mediator. As you know from the material sent through to you, I have practiced for 10 years as a mediator. Whilst every situation is unique, I have considerable experience of working through the kind of problems we will be discussing today or will be dealing with. Then, neutrality and impartiality statement. I am a neutral and impartial party in the mediation, and you do not have to try and persuade me about the merit of your case. If at any stage you feel lack of impartiality, please let me know, right? Then checking understanding. The objective today is for you to make decision on the issue you are facing, and my role is to assist you in that process. Are there any questions? Then preview of the mediation. You tell them about the preview of the mediation. So this is what will happen in the mediation process. Shortly, I shall ask each of you in turn to explain to me your concern. This need only be brief overview, as there will be time later to go into the details. After you have each made a statement, I shall summarize it back to you, and then we shall confirm the matter in respect of which there already is agreement and what matters still require decision. So as you saw in the video, as they finished talking, he summarized it back to them and he used it to create the agenda. So I shall then write these issues on the whiteboard or flip chart. We can use it as an agenda for the meeting. You then work through the issues on the board or chart, looking at the options for dealing with them and making as many decisions you can. Separate meeting. As normal part of the mediation process is for the mediator to meet separately with each of the parties. As you have advisors, I will meet with you and your advisors together. So this gives me an opportunity to see how the mediation is going for each of you. It allows you to also raise matters which have not come up when we were together, and it allows the other party to also have a break and to think about settlement options. Is that understood? Do you have any question to that? So it is only an opportunity for refreshment. It is also an opportunity for refreshment and to make any calls if you need to. Are there any questions? Of course, this is a flexible process and anyone can ask for an adjournment at any reasonable time or considerable time that you two of you will agree. Confidentiality. I need to refer to one more matter before we begin. Okay. So I need to refer to one more matter before we begin. Mediation is conducted confidentially, which means that insofar as the law allows, I will not disclose anything said here today. I'll be taking some brief written notes, but this will be destroyed after the mediation and cannot be accessed by either of you. So that brings us to very important critical point, which is information to keep and information not to keep. So when people are coming for mediation, if it is a center, they will file their processes to come, their mediation process, that you have a form for them to fill and for them to bring their matter. That one, you keep it. When they go for the mediation, they will sign consent to mediate, you keep it. But in the mediation, during the mediation, the note that you take, the paper that you give to the parties to also take the note, at the end of the process, you destroy them. You destroy them. So that is what we are talking about here. Then mediation is also conducted on a without prejudice basis, which means that should the matter go to court, which you hope it will not go to, then neither of you can lead evidence about what the other said at the mediation or produce document which they made for the mediation. Do you understand this basic principle? Please check with your solicitor if you require more advice on these points. Agreement binding when signed. So as regards the outcome, the situation today is that any agreement will not be binding until they have been reduced to writing and signed by both of you. Is that understood? If they don't understand, you can refer them to a section of your country's act which talks about the binding nature of mediation outcome that has been signed. Questions and commitment. Before we begin, are there any questions which either of you have about mediation generally or about what will happen here today? You can ask them, then they will tell you. Good. Are you both then prepared to continue? the line as I've outlined, then you say yes, then you continue. Now, time to sign what you call consent to mediate. So as I indicated to you earlier about your commitment to the process, I have reduced all the things I have discussed with you into a document called consent to mediate. This document gives me the authority to sit with you and have this matter resolved. Both parties will sign and I will also sign. You can go through the points step by step before signing. So let me show you what consent to mediate looks like. So this is consent to mediate. You see, Africa Center for Collaborative Dispute in the matter of alternative dispute solution mediation between the claimant and the respondent. So you see here, consent to mediate. Consent to mediate. So we, the unassigned parties, hereby voluntarily agree to participate in the mediation session facilitated by a mediator from the African Center for Collaborative Dispute Solution. We understand that mediation is voluntary and confidential process aimed at resolving dispute amicably, and we willingly commit to engaging in good faith effort to reach a mutually acceptable resolution and agree to commit to the terms below as ground rules for the process. That AfCoD serve as our mediation center to facilitate the mediation process. That Mr. Izikasari, a mediator from AfCoD, serve as our mediator. We acknowledge that participation in this mediation session is entirely voluntary and we have not been coerced or compelled to attend. We understand that we have the right to withdraw from the mediation process at any time without prejudice. We agree to maintain the confidentiality of all discussion, documents, and information shared during the mediation session. We understand that the mediator is bound by confidentiality and will not disclose any information shared during the mediation without our consent, except as required by law. We commit to participating in the mediation session with honesty, openness, and desire to resolve our disputes. We understand that the mediator is impartial and neutral and will not take sides or impose solution, but will facilitate constructive communication and problem solving. We understand that any agreement reached during the mediation will be voluntary and based on our mutual understanding and consent. We acknowledge that the mediator does not provide legal advice and make decisions for us, but will assist us in exploring options and reaching a resolution that meets our needs and interests. We acknowledge to participate in the mediation session for the designated duration to adhere to a guideline or rule established by the mediator. We understand that either party may request to terminate the mediation session at any time, and the mediator may also terminate the session if deemed necessary. That both parties agree to exploit caucusing whenever necessary during the process. That 14, that mediator, by virtue of his or her role, shall under no circumstances be or serve as a witness for any of the parties in this matter, nor be used in any court of law for his role as a mediator. And 15, the cost of the mediation shall be this, and it will be the joint responsibility of the parties, that each party shall pay 50% of the mediation fee. The mediation fee shall be paid before the commencement of the mediation. The that when the mediation process breaks down, the mediation fee shall not be refundable. That both parties agree to respect and comply with all undertaking made during the process, and the outcome shall be binding. So this is how then you have the parties' details here, and then the signature of the mediator also comes here, if there are the two of them. So you see the mediator side is different, where mediator only your signature and your name, but the parties there you see signature, name, address, and telephone number. So you have to know the distinction on that, right? Any question on this that I've shown you? Hello, are you there?
Yes, sir.
Any question?
Yes, sir.
Okay, please
It's
go
a
ahead.
bit tiring. Actually, I'm not seeing it clearly. Where both parties have to sign with their addresses. Can you open it a little bit?
Can you see now?
Yes, sir. It's clear now. Okay. Okay.
Right, so that is
Thank
how
you.
it is. Okay, so at the end of the training, we'll share copies with all of you. Those who have finished paying their fee for the training, we'll share copies with you. So it's not an issue. Right. So I think we've been talking for long. Let's take some 15 minutes break before we continue. Or what do you think?
Yes, we can break.
Or 5 minutes. Okay, let's do 5 minutes breaks. We are supposed to break at 1 p.m. So maybe let's take 5 minutes break.
Thank you.
Okay, so in the next 5 minutes, we'll be back. So please, 5 minutes break, take some water and walk around small. Thank you. Okay, so let's move on. So as we have shared with you, so the consent to data showed you. So when you get to that point, the sign. So having explained all the things, you see the things that were explained here, or some of the things were captured on the consent to mediate. So you tell them about it, about consent. So as I indicated to you earlier, about your commitment to the process, I have reduced all the things I have discussed with you into a document called consent to mediate. This document gives me the authority to sit with you and have this matter resolved. Both parties will sign, and I will also sign. You can go through the points step by step before signing, as I showed you. Then they sign. So once they finish signing, then you now transition. Now you are going to the next phase, having prepared them, having done your opening statement. Now you are transitioning to the next stage. So the next stage is where you thank them. So thank you for signing the consent to mediate. This is our first agreement that you have made together. Elizabeth, can you tell me what your concerns are here today? And the same to the other party. So when Elizabeth finishes, you thank Elizabeth. Elizabeth, thank you. And now said, tell me your concerns here today. Then you also thank him, and you do that. So in delivering the mediator statement, where in delivering the mediator's opening statement, where there are two mediators. So this is what I was telling you the once you asked you to talk. Yes, this is where the point is. So this is where the point is. There should be no sense of hierarchy between co-mediators. If you are co-mediators, there should not be any sense of hierarchy, which entails that they should share the statement, not leave all or most of it to one mediator. So there should not be any hierarchy. So how they divide data is up to the matter of logic, convenience, and training. So subject only to the necessity of operating as a team, because a division of tasks is more important during this stage of co-mediation than in later stage. So co-mediators require a clear understanding of who will say what and what their cues are in order to operate as a team in delivering the statement. So question arising out of the mediator's opening statement. So having done your mediation opening statement, sometimes parties may be asking you questions. So question asked at the invitation of the mediator at the end of the statement should be dealt with as clearly but briefly as possible. Solicited or unsolicited, sometimes you may not even have solicited it. People will ask questions, so you must answer. So solicited or unsolicited questions during the presentation of the statement can be dealt with there and then in a like manner. Or the mediator can advise that they would be answered later in his or her opening. A delicate balance is required because satisfying the needs of the questioner on one hand and also avoiding over elaborate answers and delay on the other hand. So it is very important to create a balance. The omission during your opening statement as a mediator, you may make omissions. You may forget certain things, but it is not fatal. So much will depend on when the mediator discovers that an omission has been made. Generally, a missing element can be added at any stage of the mediation. Provide the mediator openly acknowledges the oversight and emphasize its normality in mediation. For example, I am sorry that I forgot to tell you in the beginning that it is a normal feature of mediation for the mediator to see the parties separately. At a certain stage in the mediation, it will be too late to also deal with certain omissions, and this might have limit or little impact on the final product, right? Then party statement. Now, the parties are asked to talk. So the party statement, in most mediation, parties or their representative will be invited to make a statement early in the proceeding. Here, the mediator hands over the parties and they have the dominant role in the process for the first time, but in a controlled and structured way. So purpose of the party statement, why should even parties make statement at mediation? Because mediation is about communication. If the parties don't speak, the other party may not understand their perspective. So purpose of party statement are: one, to allow each party to make their first contribution without interruption or confrontation and to satisfy their need to have their say and be heard. So they have opportunity to have their say and also they have been heard. That is very important in mediation. Right then, to provide information to the mediator about the parties' concerns, particularly where the mediator has had no prior contact with the parties, as a basis for understanding the dispute and developing an agenda. So it provides information to the mediator about the parties concerned, particularly where the mediator has had no prior contact with the parties, as a basis for understanding the dispute and also developing an agenda for the discussion. And to also provide basis for the mediator to acknowledge what the parties have said so as to satisfy their needs to be listened to and know that they have been heard and know that they have been heard. Then to provide an opportunity for each party to hear the other party's presentation in a letter's own words and thereby understand what their current concerns are. And also it gives everyone the bigger picture. Once they talk now, you understand, oh, this is what the issue is about. And it also gives each party an opportunity to assess the credibility, sincerity, and other qualities of the principals and decision makers. And also to confront each parties with some aspect of their own case in order to create doubt about their own position. Sometimes maybe what somebody told you and you form that opinion about that person. Once the other person start talking and you listen to the person, you realize that, ooh, I didn't know this is how the issues were. Oh, I wouldn't have done this if I knew this. So these are the things that it is important. Okay, somebody send us a message. Let's see. Somebody said he cannot hear me. Who else cannot hear me? Hello, can you hear me?
Yes, I can hear you now.
Okay, great. Now let's move on. Then the next thing is to achieve a day in court benefit for the parties, so at least their issue has been heard, and allow venting and for cathartic benefits. Sometimes parties need to vent what has been on their chest for long. This is an opportunity, and without being heckled, without being stopped, they had the opportunity to express themselves. So they vent and also for cathartic benefits. To give the mediator a sense of the dynamics, who leads, who influence, and who is respected. The purpose of party statement continues. So to allow the parties to acknowledge, if appropriate, the relevance of their relationship. It is not within the purpose of the party statement to encourage discussion, direct discussion. So this is not where to, the moment they started comment, oh, I'm ready to do this, and then you started, okay, then if you are ready, what do we do? No, it's not at the point to start direct a discussion or negotiation. Experience suggests these aims and objective could be premature and counterproductive at the early stage. Timing is important in mediation, and the mediator has control over time. Then, focus of party statement. Who does the parties talk to? Or how do you focus the parties on how they talk about the issue? You, the mediator, it is your responsibility to do that. So mediator can invite the parties to focus on different factors in their statement, though the extent to which the guidance will affect what the parties actually say is unpredictable. Thus, mediator can attempt to make the focus and content of the opening statement. One is fact-based. So sometimes if the mediator wants information, certain information, then if he wants to go on fact-based basis, Then he will ask questions like this. For instance, tell me what the history and facts in this case are as you see them. So tell me the history and facts in this case as you see them. So the person will tell you. And it started from here, and this is what I see, this is what I know, this is what I know, this is what I encountered, this is what I've experienced. So that is fact-based. Then we have right-based. Tell me what your arguments are and evidence are. Tell me your arguments and your evidence to the claims you are alleging, so they can talk about them. Then there are certain issues that you can also go positional. Tell me what you are here for. What do you like to achieve in the mediation? That is positional. Positions are always looking for what to achieve, what to achieve, what do I get. Then you can also go on legalistic. Tell me what the issues are between you today. Tell me what the issues are between you today. Or you can go narrative way. Tell me what happened and what effect it has had on you. So this one, the person will now narrate what happened. It will be in a narrative way. This is what happened. This happened. This happened. So sometimes they can narrate it in a chronological manner for a good understanding. So depend on the issue. Then we have interest bills. Tell me what your concerns are today. Tell me what your concerns are today. That is interest based. Then we have problem solving. Tell me what decision need to be made today. Then procedural based. Tell me first how you think we should go about resolving the problems that we are dealing with. So this is procedural based. First, do this. Secondly, tell me what this. So you must master this. Sometimes you can use one or two in the mediation process. At every point, you will know which one to use. So they will be for you, which will be your notes. You can refer them at any time that you have mediation and use them accordingly. Then once you are handing the baton to the parties also to speak, then the question has also been who speaks first? Who speaks first? And so most mediators decide who speaks first, who make the first party statement. This is the preferred practice. It shows that the mediator is in charge of the process and it prevents any conflict between the parties at an early stage. So in making their decision, it is useful for the mediator to have both a private rationale for their decision and a public rationale for their decision or public explanation. So you, the mediator, can decide, but you must have your rationale behind it. But sometimes, in most cases, you allow the person who has brought the matter, the claimant, to talk first. So the claimant will now talk about the issue. Then the other party will also come in with their issue as well. So to whom are the party statement addressed to? There are two options for the direction of the party statement. As has already been indicated, the party statement can be addressed to the mediator directly, not to the parties or not to the other party. This avoid heated or even hostile interactions between the parties in an early stage. So in an early stage of the mediation, you don't ask the parties to talk to each other or direct the issues at each other, because that can bring a heated argument which can affect the mediation process. So on the other hand, where the parties are experiencing or comfortable with the mediation process and are professionals and are articulate, the mediator may encourage them to speak directly to each other at the opening stage. That can happen, but if you are not careful, it may jeopardize the process. So if you are not sure of what will happen, let them address the matter to you. But once they are addressing the issue to you, the other party is also there, so they will definitely listen. So encouraging direct statement can give an opportunity for parties to reconnect with those with whom they have worked or had a relationship in the past, and can encourage cooperation at early stage of the mediation process. Mediator's role during the party statement. What is your role, mediator? when the parties are talking. Your role, the mediator main role during the party's presentation is to listen actively. You listen actively. This requires, we are not saying just attentively, but actively. Actively means that your body gestures and the way you conduct yourself when they are talking is very important and critical. So this requires mediators to exercise good listening skills and display appropriate nonverbal language during the party statement. They may also have to ask questions, but these should mainly be open questions. So some clarifying question may be necessary where a party is unclear or ambiguous, but this is not the time for seeking detailed information, asking probing questions, or otherwise embarking on series of leading questions which either distract from the party telling their own story or make them defensive. When a speaker stops talking after only speaking very briefly, the mediator invites more information by asking in an open-ended way. Is there anything else we want to add, or would you like to go on? These are ways to invite them to add on. Maybe the information that they have shared is scanty and it doesn't give any perfect understanding. So as suggested, that the mediator intervention will also be required when a party's statement is excessively too long. Some of them, if you leave them, they will talk, especially if you are not careful in narrate, tell me what happened, the narrative way. If you are not careful, you sit there the whole day. They can talk and talk and talk. I remember I did some mediation. In fact, the woman was talking and I nearly slept in front of them because she started from where the man met her, how the discussion that they had, why she agreed. You are trying to even tell her that yes, we will go in details into that. So we want to know the overview of this particular issue. Oh no, she wasn't ready. And she went on and on and on and on. And sometimes, if you are not careful, you will sleep. So sometimes some of the things may be too long and boring, but you have to stick to that. So here the mediator should restate the purpose of the party statement as being to provide only an overview of the problem and reassures the speaker that there will be a later opportunity to go into detail. Where there is repetition of particular facts or theme, the mediator will need to be acknowledged, or they need to acknowledge the point being made and even write it down to cure the broken record symptom or system. Another role for the mediator during the party statement is that of the note taker. So you take note, especially when they are talking for the second time, not the first time. The first time, because you are doing active listening, you shouldn't be taking note at the same time. So if you are not careful, parties will say that you are not listening to them. So normally we don't encourage that at the first instance. You start taking notes. Some mediators may take notes, but we do not encourage that. So most mediators take only brief notes, usually words or phrase, to record key concerns. And so sometimes they when the parties are talking, they provide certain key content so that they can use it for the discussion. Then common grounds and areas of potential agreement and perspective concession. It is difficult to practice good listening and to take comprehensive note at the same time, though there can be a division of this labor between co-mediators. That's why I've said that in doing mediation, normally note taking from the beginning is not necessary so that you can actively listen to them and understand whatever issues that they have brought before you. A common form of note taking is as follows. The mediator divide the page with a vertical line and heads each column with the name of different parties. As the mediator records words or phrase under the appropriate columns, he or she can connect concerns common to both parties and also with a line or numbered asterisk to assist with the latter development of the agenda. Then request for a reply. This is also key to also note that sometimes parties may request for a reply in mediation. The party finished speaking and said, the mediator, I want to reply, I want to say something. No. The first speaker or the advisor might ask for a reply after listening to the second speaker. In most instances, this should be denied for the same reason that the second speaker was asked to not to respond to the first speaker by statement, but to respond to the issues. A mediation is not a debate or a courtroom combat, and a reply is likely to improve. A reply is likely to involve justification, denial, or excuse, and lead to an adversarial confrontation too early in the piece. A summary of the party statement is a more appropriate and development at this stage. So the mediator summary. So the mediator, when the people also finish talking, you must summarize what you have heard to the party. So mediator typically thanks each party. Thank you for listening to the presentation and for each party's openness and frankness. Some, but not all, mediators summarize the party statements, normally after both parties have made them. So as you are learning it fresh, what I normally advise is that when each party finish, summarize it and put it back to them so that you get the understanding from each party before you put the each party summaries together and create the agenda. So do it individual. To summarize the first statement, only after it has been made would be to devote excessive attention to the party and to leave the other party in the court. The statement summarizes several functions. To reassure the parties that they have been heard correctly as regards the content of what they have said. So when you are able to recollect and also summarize what they have said with them, the parties know that, and that's where they also use to build trust in you that the mediator understands us, the mediator have hired us, and that we believe that he can assist us. Then it provides some acknowledgement and validation of the emotional side of the parties, enables mediators to check the necessary accuracy of their understanding of what has been said and provide feedback if they have got things wrong. Require each party to hear what the other has said for a second. Allow a party to add to their statement when they realize from the summary that it is deficient. Then we have types of summary that you, the mediator, can do. Actual summary. Some of the parties' actual words are used so that they hear from the mediator's mouth and same term they have used themselves. Early words and phrases in particular are restated in their original form. Then we have reframe. Sometimes some of the parties will use vulgar language, some words which are unpalatable. So you need to reframe them. So the mediator reframes the party statement so as to shift to interest, remove the stage from any comments and focus on the future. In this method, the mediator avoids the actual words of the parties and provide a sanctioned or a sanitized summary. So the mediator provides a sanitized summary so that nobody will find fault with it. Some of them, they will be speaking and at the same time insulting others, but you don't need to summarize those things. Then we have cross summary. This is also one of the dangerous ones if you are not careful. It can also cause issues. So cross-summary, the mediator asks each side to summarize what they have heard from the other side in order for them to walk into the other side's shoe. Sometimes it may be good, some situation it may be bad. So actual summaries give the parties the experience of being heard. In actual summary, the mediator should use the second person and reported speech. By way of summary, you told us that, or you said that. You don't say that I heard that. No, by way of summary, you told us. It is the party that told you, not what you heard, what they told you. This distances the mediator from the statement which are hostile to the other party. Therefore, the mediator should not use hostile words. Cross summary involves several risks and for limited potential. So note, we have shown you, but be careful when using it. Then we have caucusing in mediation. A caucus is a private meeting between the mediator and just one of the party or a section of the parties. We may have claimant, two claimants. So maybe the mediator may meet one claimant and meet the other. So it's that one party, a party, just one of the parties that is held out of the earshot at the blind side of the other side. In some mediation, there are no caucuses at all. So not every mediation that you see caucusing, like the video that you watch where he got an impasse and he break them into caucus. No, not every mediation brings about caucusing. Whilst in the order, the mediator may caucus with each side once or multiple times, depending on the situation. It is always up to the parties to decide if they want to use private meetings. So caucusing can be seen as a carefully considered strategic intervention, as Chief Rose and apart Family Mediation News, Winter 2007, Association for Conflict Resolution. Some mediators feel that caucusing gives the mediator too much power. Some of them think that. Then some of them think that these mediators see themselves as facilitated with the real power held by the party. So there has been a debate around it. So caucus may be especially appropriate anytime the mediator intervention runs the risk of creating an appearance of uncertainty, weakness, or embarrassment in one or more parties. Most mediators will try to avoid having a party lose face in front of other parties. Reason for caucusing is to create a productive pause. Yes. So now here, I'm going to ask you, somebody should read number one, then the next person will read. Let's go, let's go, let's go. I have to also hear from you. One person should read one. Reasons for caucusing. One. Somebody should read it for us.
To create a productive pause in the process, relief from tension.
Great. So relief from tension. So maybe they have been having impasses, they have been having heated arguments within the mediation. So once the mediator decides to break them, now it releases them from what? The tension. So number two. Kanye, your microphone is on. Number two. Hello, Kanye.
Donc, on n'a pas encore déballé ce que l'administration a recommandé là.
Okay, so last person, somebody should read the number two for us.
Okay. So to engage in meditative reference point or what if processes.
Okay, so it is to engage in mediative references points. So what if processes? So what if this? What if about this? Well, have you looked at it? What if this happened? What if this? What if you see this? These are the things that you also enter into. Then third, let's go. Who is reading? Christy, read third and fourth.
Permit party movement without losing face.
And 4. 5.
Offer
And 4.
4
Okay,
and
4.
5. Okay. Offer negotiative advice. And then 5 says that assess alternative to negotiate settlement.
Okay, great. So during the caucusing, this is where the mediator assists the parties to evaluate their work and to evaluate what they are saying, and to also find out, if you look at the video, find out what are other issues that you think can affect the mediation process that you are hiding from the other party. You see, the other one, his daughter was sick, but he couldn't share during the mediation process. But during the caucusing, he was able to bring it up. These are some of the things that you discuss with the bar without the person what losing face, because maybe he's unsure about if he brings these issues at the plenary session, what will happen, and what issues that the other party will say. And sometimes you evaluate with them so that they will know, ask what if questions, so that they will know how they will go inside to negotiate. So this is where, have you considered this, the negotiating advice that you give, that have you considered this, have you considered, so the mediator indicate that, would you mind sharing this information with the other party? Would you want me to share? Or he said, no, I would rather share during the mediation session. Then assess alternative to negotiated settlement. If you don't get what you are looking for, what other things do you think when you get it will be okay for you? These are some of the things. Then test whether a party's proposal are realistic. Sometimes you serve as a sounding board to check what the other party is saying is realistic. Then you act as a sounding board, work to develop settlement proposals, then as means of gathering information that would not otherwise come out during the plenary session. So caucusing again during confidentiality during caucusing. So if the mediator chooses to caucus, it is critical that the mediator and the parties reach clear agreement as to the confidentiality of the caucus meeting. This can be done in the agreement to mediate or less formally during the mediation itself. So best practice is to clarify agreement as to the degree of confidentiality of the caucus session and any exception to such confidentiality in writing. Mediators and parties will typically take one of the two approaches. Everything said in the caucus is confidential. So sometimes everything said is confidential. Then everything said in the caucus can be shared with the other party with instruction. So sometimes they can provide certain instruction. Right. So the mediator is advised generally also after caucusing. What do you do? The mediator is advised to generally caucus with all the parties if he or she caucuses with any party. The purpose of this is to maintain balance. There may be situation where this is not necessary, such as where one party wants to specifically discuss a settlement option in private. The other party does not feel that they need to do the list all things you believe we may be able to easily agree on. So you do them, come up with at least 2 settlement arrangements that will work for you. Then what would you be willing to give the other party to get what you want? And what would you need to receive from the other party to agree to what you want? Now, having done all these things, we are putting all of them into a summary. So as a way, if you are doing as techniques to do the mediation, if you are doing mediation, this is how you go about them. This is how you go about them. So one, preparation stage. So the preparation stage, that is where you, the mediator, gives your opening statement. So you give your opening statement. So you establish the ghost protocol. The ghost protocol means that the parties have to be what? Gentle, honest, open, sincere, and to talk. So let's all say it together. G stands for gentle, H stands for honest, O stands for open, S stands for sincere, and T stands for talk. So that is what ghost means. The ghost, not the ghost that you know. This is ghost in mediation, a protocol in mediation which helps parties to be sincere, talk, open, honest, and gentle in the mediation process. And so then establish confidentiality, confirm authority, confirm time, describe your role for the mediator and the parties. Then you transition. Are you ready to proceed? Once they are ready, you proceed to the next level where you are going to gather information. So the need for the mediator to have what you call active listening. So you, the mediator, you must be able to pay close attention to each party's perspective, demonstrating empathy and understanding. Then, so demonstrating empathy and understanding. Open-ended questions. So encourage parties to share their thoughts and feelings, fostering a deeper exploration of underlying issues. So then before you go to that, so having this at the back of your mind, then you go into the storytelling stage or the uncovering stage. So now you are going into where? Interest-based approach. What are you here to resolve today? What are you here to resolve today? Listen, look at the speaker. No note. So your technique is that listen, look at the speaker. Look at the speaker. No notes. Don't be taking notes. Listen, look at the speaker. Acknowledge each party speaks. Thank you. So thank you. Reframe to neutralize a word or create title for conversation. Thank you for sharing your issues with me. And I must acknowledge that this must have been a difficult situation for all of you. If I heard you right, you mentioned A, B, C, D. If I heard you right, you mentioned A, B, C, D. So each party, after each party has spoken, you summarize them. So you create, as we were talking, you create the horizontal lines. So you divide the page into two. So party A, the claimant, then the respondent. So when the claimant is talking, you after that you summarize. So if I heard you right, you spoke about this, spoke about that, then you finish. When the party B finish, you spoke about this. So if I heard you right, so if there's any thing that you have to reframe, then after that, based on the two of you, what you have shared with me, I can see that there are issues here, and that. Is that the issues that you want us to talk about? They say yes. Can this serve as our agenda for the discussion? They said yes. Then you have something to deal with. Right. So reframe to neutralize a word or create the title for conversation, confirm and write them on the chat. Right. Then you go to the next stage, which is the learning stage. So significance of the circumstance, the parties now talk to each other. Now, once you have an agenda to talk to it, so looking at this agenda, what do you think should be the solution? So you talk, you listen to you look at what they can do. So parties now talk to each other. Remind them of the ghost protocol. This is where it can be heated small. Invite the parties to talk to each other. So tell each other what is important to you. Looking at this without starting from no particular order, can we start from communication first? So tell each of you what you wanted to see in respect of maybe communication, in respect of maybe they are talking about maintenance, in respect of maintenance, what were your expectations? Tell each other. So listen, look at the listener. Wait, now you can take notes. So this is where you generate the option, start generating the option. Trust in the process. Wait, let them talk. This one, it can be heated, but wait, let them talk. Support conciliatory gesture. What do we mean by conciliatory gesture? Somebody will be talking, somebody might have mentioned that, oh, I didn't know that this was what the situation was. I wouldn't have done ABC. You pause and you tell them that, wait, please, can you repeat what you said? Then you repeat again. Or if I heard you right, you mentioned something like this. Can you explain? Can you elaborate on that? Then he explained. When he explained, he said, you have the other party. What do you think about that from what he has said? Then now you are building a consensus. So trust in the process. Wait, let them talk. Support conciliatory gestures when left unnoticed by the other party. Confirm prospect on the chat. Now confirm the prospect, what they have agreed upon now on the chat. Now, based on what the options, you are now going to search for possibilities or possibilities. Your opportunity now is to generate options that will meet your unique. So these options become the terms. You are now generating the options. So generate option that will meet your unique common needs. I'll capture your ideas here on the chat. So you still divide the book into two. So Patty, tell me, looking at what you have discussed so far and the issues that you have raised, what do you think will be the solution to this problem? So tell me what you want to do. Then they will be telling you, I want this, I want that, I think this, I think that, I think that. At this stage, alternatives or possible solution must be generated. The problem works best when there are ideas to work with. Write down all the options, analyze each option with the parties one by one. Then explain, what do you agree to do? What would you like the plan to say? So now, having discussed the options, so based on these options that you have raised, what have you agreed to do? So they will tell you, what do you like the plan to say? So the plan, maybe they have agreed that there's an amount in dispute and they have agreed on the amount. How are they going to pay the amount? Is it by installment, once-off payment, or two-time payment? So that is what the plan will say. If it is access on a child, what would the plan say? Maybe you come and pick the child every 2 weeks. What is the meeting point? If it is maintenance, how much have they agreed? Where would the money be placed? Is that an account, mobile money number? This is how the plan will say. Confirm the plan by reading it out to them. Then confirm commitment to the plan. Then closing. So review the purpose, review the process, tear up the notes to confirm confidentiality, the ones you took, not the outcome, the one you took. Then confirm feasibility and authority to implement the authority, and treat parties to use the protocol techniques to deal with one another in other circumstances that may arise between them. Thank you so much. Any question? Any question, please? Okay, thank you so much. The next facilitator is here. Thank you for joining us. If you can hear me, good afternoon. See what say. If you can hear me, please. The floor is yours. You can continue.
Okay, good afternoon, Mr. Isaac. Good afternoon, everyone. Please confirm if you can hear me.
Yes, you're audible and I can hear you.
All right. Thank you so much. So once again, good afternoon. It's afternoon from my end. I don't know, my video is not coming up.
Good afternoon, madam.
Thank you. Sorry, it seems I'm trying to share my slides now.
Okay. Okay, it's working now.
Okay, you can see my slides, right?
Yes.
Okay, so I'll just go straight on so that we'll begin. Okay, I think my video is up now. So once again, good afternoon, good morning, perhaps good evening, depending on your time zone. At this hour, please just give me a minute. So I'm excited to be here. I'm delighted to be here, and I want to appreciate and congratulate every one of you for being on board today. I believe that the training has been very impactful right from yesterday. So I'll just key into the foundation that has been laid before now, and then we'll just begin. So I will start by introducing myself, and we'll just get right in. Sorry, just a minute. Okay, so by way of introduction, I'll be taking you on today's training for on the topic rather, communication in mediation and emotional intelligence. Sorry, please confirm if you can still see my slides.
Yes, your slides
Okay.
is visible.
Okay, so I'll just go on ahead. So I'll be taking you on communication in mediation and emotional intelligence. And I'll start by introducing myself briefly. My name, as already mentioned, is Sewese Yaji Aondu. I'm a lawyer called to the Nigerian Bar, a dispute resolution specialist, ADR practitioner. I'm also a certified data protection officer, a certified management trainer, a facilitator, a chartered manager, human resource consultant, and then I also I'm certified with the Institute of Conciliators and Mediators in Nigeria, and AfCCoDR in Ghana, and AfCCoDR International in India. And by God's grace, I'm also the ACPSEA National Coordinator for Nigeria and the founder of Prime SPG Legal Consult, a commercial law firm that offers services, generally corporate services and alternative dispute resolution services. So we'll go right in. I'd like to begin with this quote by Shannon Alder. It says, if there's no communication, then there's no respect. And then it goes on to say, if there's no respect, there's no caring, and there's no understanding. If there's no understanding, there's no compassion. And if there's no compassion, then there's no empathy. Then there's conflict. And if there's no empathy, then there's conflict because there's no communication. So this lays an emphasis on the importance of communication, not just in mediation alone, but generally in our everyday life. And there's also a saying that at the root of every conflict or dispute is ineffective communication. There's always a gap in communication. If you look at the root of every conflict or dispute that comes to you as a mediator, you would always see that there's definitely a gap in communication that has resulted to that misunderstanding or disagreement or whatever the underlying issue is. So having said that, we'll go straight to the introductory part. And I like to pause here and say that because it's an online session, please, at any time that you do not, you can no longer hear me clearly, please feel free to interrupt me. If you have any observations, questions, or concerns, also please feel free to interrupt me. But other than that, I'll just flow with the class, and then we'll get to the point where we'll also give room for other conversations like questions and additions and comments. So thank you. So by way of introduction, when parties come to the mediation table, they are coming in with very high emotions, tension, anger, distrust, and then so in that situation or in that state of mind, when they communicate, it's very difficult to understand themselves. A lot of people at that stage say what they do not mean, and they do not even mean what they say. They also do not understand what is being said to them or whatever the conversation is about, because they've already come in with a particular mindset, right? So your role as the mediator is to calm down the emotions, bring down the parties to a level playing ground so that they can communicate effectively and understand themselves effectively, understand what the problem is, understand how they can move from the position they came in with to a position of interest, and then finally dialogue and settlement. So based on our topic today, communication in mediation and emotional intelligence, we are beginning with communication. And we know communication generally is exchange of information between parties. We have the sender, the receiver, and there's a message that is being passed across. There's a medium or a channel through which that message is being passed. And there's also feedback. That feedback. Sorry? Is someone saying something? Okay, so I'll go ahead. So by way of introduction, we'll look at what effective communication is. And like I was saying before, when communication is passed between the sender and the receiver through a particular channel, there's feedback, and that feedback would show if or indicate if the information passed was actually understood or not. So effective communication, we'll zero it down to mediation specifically. So effective communication in mediation is at the core of mediation, is at the heart of a successful mediation. For mediation process to be successful, the communication must be effective, and the communication is, I like to say, is a two-way part. The communication between the disputing parties themselves, and then a communication between the mediator and the parties themselves, right? So effective communication equips mediators with the tools to foster understanding and resolution. For a mediation to be successful, the mediator has to build that environment, that rapport with parties. It has to build trust, and this will enable parties trust the process and willingly give into resolution of the dispute. So the term communication covers a multitude of skills, processes, and techniques that the effective mediator must develop and improve. Emphasis on must, because as we will see as we go ahead, once there's no effective communication, just like we said at the beginning, once there's no effective communication, then there will be no understanding between parties. And once there's no understanding, then there's no way that they can move to the position where they agree and resolve the issue. So the mediator, as the facilitator, has that major role to ensure that there's effective communication. So mastering these skills by mediators helps to create an open, unthreatening, and constructive environment that leads parties to greater understanding, flexibility, and willingness to find satisfactory resolution. And like I said, it also builds trust in the process. All right, so we'll go ahead to look at uh, a clear definition of effective communication as can be seen in mediation. So effective communication in mediation is therefore a structured, collaborative process utilizing active listening, empathy, and neutral language to foster understanding and resolve conflicts. So you see that for communication in mediation, the aim is not just to pass the message across from the sender to the receiver, and maybe through a particular medium, maybe through writing or through mail or any other means. The essence is that through effective communication, parties are able to adjust. So they've come in with particular specific positions, adversarial positions, but through effective communication, they are able to adjust and move to the point where they are negotiating based on interest, and then they are shifting to the point of clarity. They now understand, oh, these are the underlying issues, this is how we need to address them. Their emotions are under check at this point, because when they came in initially, remember I mentioned that they come in with high emotions, there's tension, there's anger, but when they've gotten to this point of clarity, the emotions are regulated to an extent, and then they can now reason together and come to agreements, amicable agreements amongst themselves. So basically, the concept of communication in mediation, flowing from the definition, focuses on the fact that communication is the backbone of mediation, is at the heart, it's the core of mediation, like I said earlier. So it's deliberate. It's not just speaking. It's not just listening. There must be a deliberate exchange between the conflicting parties, deliberate exchange of meaning, deliberate exchange of information between the parties themselves. Like I mentioned, it's a two-way path between the parties themselves and then the mediator and the conflicting parties. So through that process, conflicting parties are able to exchange information that would lead to understanding of their issues. They are able to unpack their emotions. So there's a shift from that high emotion to a regulated emotion. They are able to uncover underlying interest, understand themselves better, and get to negotiations based on their various interests. And then when this happens, it means that they can come to an agreement. And so the role of an effective mediator is in order to promote effective communication, is to utilize specific verbal and non-verbal techniques to bridge the gap between disputing parties. So we'll see as we go ahead that communication is made up of verbal and non-verbal cues. So it's not just, in fact, research, as we'll see as we go ahead.
No, sorry, can be there, sir. The best concrete there.
Okay.
On any debut or the share. Concrete is now.
Mr. Hayford. Thank you. Please, let's ensure that we all mute so that we do not interrupt the class. Thank you. So like I was saying, an effective mediator is able to utilize specific verbal and non-verbal cues. Communication itself is made up of non-verbal and verbal cues. As we will see as we go ahead, we'll discover that, in fact, the non-verbal cues or non-verbal form of communication makes a larger percentage compared to the verbal communication. So most times, what people are, there's a lot of meaning in what people are not saying than what they are saying, especially in a conflict situation. So the mediator must be equipped enough to be able to dictate both the verbal cues and the non-verbal cues as well. So what's the reason why we communicate? Generally, these reasons apply, and then specifically in a conflict situation, these reasons also apply as to why we really communicate. So the purpose of communication could be any of the following. People communicate to express their feelings, thoughts, their ideas, emotions, and desires to the other party. In the case of a mediation setting, people would express their feelings, the thoughts to the disputing party, or to the mediator as who is facilitating the process. And then communication is made so that people can understand how what is really going on in a person's mind, how the person is feeling, how the person is the thought process of the person. Then we could say communication is also for the purpose of inspiring maybe the other person, or motivating or persuading the other person, or informing the person, or to also express an unmet need or demand. I think almost four of these reasons for communication apply to communication in mediation as well. So we'll go ahead to look at the various forms of communication and the barriers to effective communication as well. So there are a whole lot of barriers to effective communication. Well, you talk about noise, you talk about stereotypes, expectations, the emotional state of the parties, the different values and beliefs that the disputing parties bring to the mediation table, the differences in their languages, their culture can also be barriers to communication, differences in their background and their orientation, maybe physical or mental discomfort. All those and many more are barriers to effective communication in a mediation process. So for the role of the mediator is to be able to identify these barriers, and as much as possible create a conducive atmosphere, try to ensure that these barriers are taken away as much as possible, to prevent ineffective communication, and to also prevent any form of power imbalance as well. So like I mentioned earlier, there are verbal and non-verbal cues in communication. And I also mentioned the fact that most times what a person is not saying what a person is not saying is actually more than what the person is saying. So from this research study by Dr. Albert, the 7-38-55 rule of communication, it shows that 7% of communication is what we get through spoken words, through verbal communication. 38% goes to the voice, the tone, the pitch of that person communicating. The 55% goes to body language. So you can see, if you add up the 38% that goes to voice tone and 55% that goes to body language, both of them are under non-verbal communication. You will see that it amounts to over like 93% out of 100% when you are trying to measure communication. So it shows that as a mediator, you must, in as much as you are attentively and actively listening to what a party or parties are saying, you must also pay active attention to what they are not saying by observing the non-verbal cues, their language, their tone, their voice, their reactions generally, in order to be able to manage effectively the communication process in a mediation setting. So, like I mentioned earlier, generally there are communication variables. But communication begins from the sender and then who communicates a message through a particular medium, and then there's a receiver, the person to whom the message is forwarded. There's feedback that will indicate if the message has been received and if it has been understood. So these basically are the processes that communication goes through generally in life, and then if we bring it down to the mediation process too, it will also apply from the beginning of the mediation process, who is sending the message, both parties, disputing parties. There's one person that is sending the message to the other, has the message been communicated? Have they understood, both of them understood what is being communicated? And you will know this through the feedback. When they come to the point of clarity, they come to the point of negotiation, they come to the point of understanding their interest and willingness to negotiate. You know if there has been effective communication or not. Then, like I mentioned earlier, there are various types of communication, but generally we divide them into two: verbal and non-verbal communication. So verbal communication is transmission of information or message through spoken words specifically. And we've seen that if we want to weigh the percentage of spoken words, we'll see that just a minute percentage, just 7% of communication goes through spoken words, like we've seen earlier through that research. And then non-verbal communication is transmission of message through gestures, written words, attitude, that body language, voice, tones, and all of that. So non-verbal communication most times provides for more accurate information as it takes place under less conscious control than verbal communication. Sorry about that. So non-verbal communication, like I said, most times what a person is not saying is actually more than what the person is saying. So we must pay attention as mediators to those things that we observe from the attitude of the parties, from their tones. Sometimes it could even be fear. They are afraid of speaking out. They are not relaxed, So you take note of that and then make accurate arrangements, make the environment conducive. It could be through the sitting arrangements. It could be the point where you realize that, oh, maybe you need to have a one-on-one meeting, a caucus with either of the parties, or even before the mediation process begins. From the facts of the case and all of that, that some of these issues exist, and then you also observe to see how you can address them and create an enabling environment for parties to succeed in the mediation process. So we've spoken about various symptoms or various types of nonverbal communication. And like I said, most times we speak not only by our words, but also by our actions. So the popular saying goes that actions speak louder than words. And so this is where it applies most times in mediation. So examples and meanings of non-verbal communications that as mediators we should look out for. When you see somebody giving, so something like a thumbs up, it implies, okay, yes, there's encouragement or approval to continue or go ahead. You see a touch with a single finger indicates call for attention. Then shaking with both hands shows warmth. A nod, obviously in most cultures it shows indication of acceptance. Then in some cultures it might actually not be acceptance, but generally I'm looking at the general and possible meanings of these verbal non-verbal cues now. So a frown or the shaking of the head implies rejection. Arm around the shoulder indicates friendship or companionship. arm around the waist implies intimacy. Palm on the lap says, I care, or I'm with you, I support you, These are just a few of those non-verbal signs and the meaning. So as mediators, we must be abreast with all of these non-verbal cues. Now you can see somebody maybe from the way the person is sitting, the person is sitting crossed with crossed arms around their chest, not relaxed. You can is a clear sign that the person is actually not in agreement, or the person those signs that would give an indication that there's something wrong, and you ensure to, as a mediator, to ensure that you move parties towards that position where you can address those issues in order not to interrupt the mediation process or prevent parties from coming to an amicable resolution. Okay, so we'll move on to the necessary communication skills that a mediator must have to ensure that to ensure effective mediation communication in a mediation process. So we've listed a few of those skills here. We'll have active listening, listening with empathy, body language, and asking the right questions. So all of these are skills, they are techniques that a mediator must have. Being able to listen actively is a very vital skill. Being able to also listen with empathy. So most times persons argue that mediation in a bid to empathize, the mediator might move from the position of being impartial or being neutral to uh, being partial, but that's mostly not the case. People would only think like that if they mistake or confuse being empathizing with sympathizing. So there are there are two different situations rather. So for the mediator is not allowed to sympathize. The mediator should empathize with parties, and you should be able to listen attentively. And if we go ahead, we'll look at the various active listening skills that the mediator must possess. The mediator must be able to ask questions correctly, in order to move parties to a point of resolution as well, and not to ignite disagreements. So we'll focus on active listening and look at guidelines for active listening. So for the mediator to be able to communicate effectively, the mediator must be able to listen attentively to what the other person is saying. So listening is not just um, staring at the party. You must listen wholly. Your mind, your body, your soul, your full attention must be given to the party when the party is speaking. So active listening is a very critical skill for mediators. It's ex- the mediator is able to master this skill by focusing on the speaker or the party when they are speaking, refrain from interrupting. The mediator is also able to just to hear beyond the words. Like I said, the mediator should be able to also observe the non-verbal cues as well. Understand the emotions of the party, the reasons that are driving the conversation, and when this is done, then there's this assurance in the parties, and it builds trust, which is a very crucial component in the mediation process. Then the mediator should also be try to rephrase or restate her response to what the party's feelings or thoughts, except they are requested for. Just rephrase exactly or restate exactly what you have heard. And in your response, don't ridicule what that party has said, whether you agree with it or not. Don't be sarcastic in your comments about the party's remark or their comments or whatever that is being discussed or whatever their contribution is. And then the mediator must also learn not to interrupt. So when the mediator has something to say, if you notice that there's a pause or a pause occurs, then that's a perfect time to go ahead to ask that question that you have. But by all means, do not interrupt when the parties are speaking. Then respond with questions. And like I said, one of the techniques for effective communication is getting your questions right. So there's a way you ask questions. You can't say, okay, for instance, the party said something, and then you want to, it's an act of rephrasing as well. So you want to respond to the question. You say something like, are you saying that this happened, or something like that? You will not say you said that, or did you say that this thing happened like this. There's a way you couch it to put the question, to put their words back to them in the way that they have said it, not you trying to maybe recouch it or maybe add your own thoughts or opinions to it. So those are basic among basic guidelines for active listening. There are a whole lot of them. And then active listening skills apply both to verbal and non-verbal communication. So for non-verbal communication, we'll apply skills, and then these skills have been summarized under what we call the soften formula. So S is for smile. If smile says that you are glad to see the parties, you make them happy, you welcome them, you are making them comfortable, you are receptive, you are open to the conversation, you are open to the process, so they are free to express themselves, right? So a smile is different from it just shows on your face, right? It's different from maybe loud laughter or giggling or all of that. You remember that the mediator must be also very professional and composed. So just a smile. Don't come into the mediation process with a frown. Of course, even if it's not a mediation process, wherever you go into, whether it's a meeting in the workplace, whether it is church, even in the home, in the family, once you come in with a frown on your face, of course, it scares people away. It's makes them drawn away from you. But that smile is a welcoming approach. It makes them comfortable with you first of all as the mediator and the facilitator, and then it also goes further to build trust in the mediation process as well. Then O is for open posture. So this invites parties and encourages them to feel free to express themselves freely, to discuss freely without limitation. And in doing this, you are able to emphasize the fact that there's confidentiality in the process. Of course, during the opening statement and all of that, you would lay emphasis on the fact that the mediation process is very confidential. It has double layers of confidentiality, both at the joint session and at the caucus level as well, except at the caucus level, except where parties permit that it should be discussed in the joint session, else it is total confidentiality. And of course, there are some exceptions to confidentiality when it has to do with the law, provisions of the law and all of that. But that's aside anyway. So F is for forward lean. So your posture, like I said earlier, you sit with crossed arms, crossed legs. It's only showing that, oh, there's you are not relaxed, you are resentful, you disagree, so by all means your posture as a mediator should show that, oh, you are welcoming, you are receptive to the process, to the parties themselves. And then on the other hand, you should also be able to interpret when you see parties in this kind of position. So a physical forward movement indicates that the party is giving rapt attention, and then of course a cross hand, cross legs, or maybe you see the person tapping their hands on the table or tapping their feet while the other party is talking. It already shows that they are distracted or they do not agree, not comfortable. Then, like I mentioned earlier, an appropriate touch. It says, I'm with you, I admire you, I agree with you, and it supports. Then eye contact is very important as well. It shows that you are paying attention and you are interested in what is being said. It must be careful with regards to eye contact to draw the line as a mediator by not staring continuously into the face. Okay.
Hello, can you hear me?
If you can hear me.
Hello?
The network is breaking. The
Yes,
network is not stable.
yes, her network is breaking. So as if you can hear me, your network is breaking, your screen is also off.
Thank you. Sorry?
Your network is breaking and your screen is also off.
Oh my God. Can you hear me now? Can you see my screen now?
No, your screen is off. It is now coming. It is loading.
Okay, let me. Okay.
Your screen is still loading, but your line is also breaking.
Share.
Okay, she's trying to log back, so let's be a little bit patient. She'll come back soon.
Okay, sir.
Okay, Madam Suwesi, can you hear me? Hello, Suwesi, can you hear me? I think I can see you here. Can you hear me?
Can you hear me now?
Hello? Hello, please speak
Can you hear
again.
me?
Yes. Now you're audible. Can you hear us?
Please, can you hear me now? Thank you. I'm so sorry.
Don't worry. As for network, we don't have control over them.
So please confirm if you can see my screen.
It's loading.
Okay.
Yes, now it can be seen.
All right. Thank you. I don't know at what
Welcome
point
back.
I
Welcome
was
back.
lost.
Sorry.
Thank you. So I don't know at what point I was lost. Do I need to go back a slide backward, or I can just proceed?
Actually, on the active listening, the non-verbal side, then you were touching on the soften approach and explaining it. I think you've done smile, then yeah, you're on the smile bit.
Oh, wow. And I'll just talking and talking and talking. Okay. So let me go back one slide backwards. Let's go back to the non-verbal. Okay. So thank you very much. Like again, I'm so sorry for that interruption. That's the challenges we face with network and all of that. So we're talking about active listening, non-verbal skills, and then I said that in this case, most times we apply the soften formula. So just have it at your back of your mind. Just have the word soften in your mind, and then it's just easy to apply. So a smile on your face says you are glad to see the parties, you are welcoming, you are receptive, that you are making sure that they're comfortable, the environment is conducive. So I was saying that a smile generally on someone's face is welcoming. So whether it's in a mediation process or anywhere you find yourself, it could be a board meeting, it could be even in the family, as a father, as a mother, or a sibling, once you put a frown on your face, it scares people away. You know. So that's putting a smile, especially in a mediation process. It implies that you are welcoming, you're excited to go through the process, and you are open-minded. Then there's open posture, which shows that you are inviting to be free in their interactions, free in their discussions, free in expressing themselves, free to express their emotions, their thoughts. You know, you talk about F, which is that when your posture tells a lot, discussion, and then you are crossed armed, or your legs are crossed, or maybe your feet, you are stamping your feet on the floor, or probably unconsciously tapping the table. You know, it's not. So a forward lean shows that you are paying attention, there's rapt attention, you know. And then as a mediator, when parties are in that position, you also know that, of course, they are paying attention, they are agreeing with what the person is saying. And then when you see them, you see a party that maybe has leaned backward, maybe the head is one-sided, is just shaking the head, or just tapping the table, and or stamping their feet. It's just like saying, I don't even understand what you're saying, or I don't agree with what you are saying. Just finish. Let me say my own. Let me say what's on my mind. You know, you see that. If you see that kind of position, it means that parties have not come to that place where uh, their emotions are regulated yet. They've not come to the point of clarity yet. Then touch. T is for touch, and an appropriate touch says a whole lot. It says, I'm with you, I can continue, or I'm in support, you know, I support you, and all of that. So as a mediator, you should be conscious what is going on in the room amongst parties as well. Then eye contact, it shows attention and interest in what is being said. So if you see that there's eye in a party, it shows attention. But I mentioned before now that stare continuously, or stare to the point where a party feels uncomfortable. So you stare, just relax and stare, and then you can break the stare for a second, 2 seconds, you know, a minute, or you know, less, like that. But staring without shaking or continuously like that, most times it puts a party in an uncomfortable position. And then if you see that parties amongst themselves, so there's a party that is staring at the other party like that, sometimes they are trying to intimidate the party, to make the party shut up or not express themselves, or to scare the party away, or to force or intimidate the party, or force the party into agreeing with what they are saying. So you have to understand that as well. And then on your own part, you also have to know what eye contact means to the parties. Then a nod indicates acceptance. It indicates, oh, I'm following, please speak on. And then I went on to say that for these active listening skills, this is what applies generally across board. But when you bring it down to cultural differences, you might see that maybe with eye contact or a nod might mean acceptance in one culture. In another culture, it might mean non-acceptance, or disagreement, or refusal, you know. And then for eye contact as well, there's that issue with eye contact in our African societies, and then the European societies as well. Sometimes eye contact in an African setting might seem like, oh, you are being rude, especially if it is between a superior and a subordinate. It might be like you are being rude. So it all depends on the setting. But for active listening skills for the mediator, just highlighted this formula that you can apply. Okay, so we'll go ahead to active listening techniques for verbal communication. So you remember that for verbal communication, it just takes about 7% of spoken words. Non-verbal takes about 93%. There's a greater percentage with non-verbal. So it takes a whole lot to understand the non-verbal cues and to be able to manage communication effectively. At the same time, it also takes a lot with regards to and spoken words to verbal communication. So one of the techniques that a mediator must have or be able to develop in order to promote effective communication in a mediation process is the act of summarizing. So after parties have spoken, after they've stated their opinions or their grudges or their issues, their interest, the party must always, the mediator must be able to outline the main points, summarize to ensure that both parties are at the same level of understanding, to ensure that they have understood what they said, they have agreed to what they said as well. Then the technique of reflecting. Mediators must be able to confirm that they have heard and understood the feelings expressed by the speaker by reflecting on what the party has said. And then reframing as well is used by mediators to help parties to move from position to interest. So a party says, for instance, I know that you what example will I use? I don't want to use maybe an insultive or maybe a party says to one party, I know that you are a very wicked person, you are very inconsiderate, and that's why you are a very considerate boss. That's why you are refusing to pay me my severance package or my allowances and all of that. As a mediator, you should reframe, because the reaction to that statement ultimately would be for the boss to be defensive, to try and protect themselves, to try and explain why they are not what you think they are, to disagree. So it will not take parties to a position of clarity. But as a mediator, if you are able to reframe that statement to say maybe that, oh, I am party A, I understand that you are hurt by this situation, and then you mean to say that like this, it will put the other party it will regulate the emotions of the other party such that their response will be much more favorable to the process. So acknowledging is another technique that the mediator must have. The mediator should be able to recognize what the speaker has said or the party has said without agreeing or disagreeing. Remember that the mediator must be very neutral to the process. So acknowledging is repeating or putting back to the party what they have said to show them that you are following, that you align with their interest or with their opinion, not necessarily saying that you are taking sides. So you must be careful in acknowledging not to show that you are impartial or you are no longer neutral to the process. Then differing, this would apply in situations where maybe the parties are no longer agreeing, or there's the mediation process is no longer moving forward. There are high emotions, in the mediator can apply this technique of postponing either the process or that particular discussion, that particular topic of discussion to a later time in order to calm the parties and then place them in a position where they are more comfortable to discuss on that topic or on that matter. Then encouraging. The mediator encourages the parties if they feel upset through the way that you are able to reflect on what they have said through the way that you are able to summarize what they have said, or acknowledge what they have said, to show them empathy. Encouraging would have to do with empathizing with the parties, to show them that you understand where they are, you understand their positions, you understand their feelings, whatever they are, but you are not taking sides. Then restating, here in the mediation process, the mediator is able to reassure the parties that he has heard them, the statements that they've made, the words that they have spoken, and then through proper questioning, like I mentioned earlier, the mediator is able to clarify or get additional information. That's the essence of questioning. And then the mediator is able to also validate and then bridge the gap to help parties to continue communication as well. Okay, so that's for active listening techniques. There are so many other techniques, but just a few of them here. Then, in as much as the mediator is able to develop techniques as to whether verbal communication or non-verbal communication, there are a whole lot of barriers that are also uh, can obstruct. There are a whole lot of barriers that can obstruct active listening. There are a whole lot of them, but I've just mentioned a few here. So, for instance, if as a mediator, if you see yourself blaming one of the parties, you are shifting fault onto one party, automatically you have become impartial. You are no longer neutral to the process. You've taken sides when you find yourself doing that. So you are shifting fault to the party, to a particular party, while the other is speaking. How does this serve as a barrier to active listening? So when you do that, the speaker feels attacked, or the party feels attacked. The party will no longer be able to express themselves openly or freely. And then you also, instead of paying attention to the party, you already have a mindset that has prevented you from hearing what the actual issue is, because you are focused on assigning guilt. You are focused on who is wrong and who is right. Remember that there's no wrong or right in the mediation process. There's no person that is wrong or right in the mediation process. There's no winner or loser. You bring parties to the point where they all agree, they are all winners, because they are able to agree to what their issues are, understand what the issues are. They are able to arrive at the agreements amicably without anybody imposing any decision on them. They are able to get to that point where they agree. And then when that happens, it means that enforcing that agreement is also very easy, because it was not imposed on parties. Then another barrier to active listening for a mediator is when you see yourself comparing. So you for every case that comes to you as a mediator, it's a new case in its entirety, whether it has similarities or not to a case you have handled or not. You approach it with a new mindset. So by the time you see yourself comparing, bringing in other cases as examples, or comparing to what to the current case, when I handled this case on divorce or family, when I handle this family matter, for instance, and the parties or the couples agree to do this while the other party is talking, then it's a barrier to active listening. It will tell the speaker that their situation is not unique to you. You already have a mindset already. So you are not actually listening to what their specific peculiar issues are. So you are rather listening for similarities that are in the present case and comparing them to your past case. You are listening for what they are not actually saying. You are adding your own thought process or your opinion to what they are saying. So that can also be a barrier to yourself as a mediator, to listening actively, and to the parties as well. And then where you find yourself as a mediator disagreeing, you are openly arguing or contradicting the speaker when they are in mid explanation or mid speaking, in the course of their speech or expressing themselves, you are interrupting or arguing with them or contradicting. It blocks listening. Remember that I mentioned that when if you want to speak, look out for that time when there's a pause is the perfect time to come in with whatever comments or communication that you want to pass across. So disagreeing blocks listening because the speaker immediately becomes defensive, they shut down immediately, they want to defend themselves, they want to argue back. So the mediation process that should be very conducive, very um, um, result driven and all of that now turns into a debate. It's no longer a conversation. It becomes like a court process because of course, oh, there's the defense. I'm trying to bring in my evidence to show why I am not guilty, and the other side as well. So you do not disagree openly, argue openly, or contradict parties in the mediation process. So those are the barriers to active listening as well. So active listening is something that is consciously developed, right, by mindfulness, being mindful. So after every mediation process, you are able to go back, review your actions, have a checklist generally with regards to managing verbal and non-verbal cues, with regards to fostering effective communication. So you can go back after every mediation process, go through that checklist, see how well you are doing, and then see how you can be better with developing those skills as well. So, like I mentioned in the beginning, we are looking at communication and emotional intelligence. I forgot to mention that emotional intelligence is also a skill, a very, very important skill that the mediator must have in order to promote effective communication and to ensure that the mediation process is successful. So somebody will ask, what's the synergy between effective communication and emotional intelligence? So effective communication is facilitated by emotional intelligence. If emotional intelligence is in expressing oneself clearly and sensitively. So emphasis on clear expression and sensitive. So you are not just speaking, because it's one thing to just speak and say things and not be conscious of how it affects the other party or how the other party feels. You must not just speak, but be conscious of, oh, this thing that I'm saying, how would the other person receive it? How would the other person understand it? So that's where sensitivity comes in. So emotional intelligence aids parties and the mediator to be able to express themselves clearly, to be sensitive, to articulate their thoughts and feelings in a non-confrontational manner, and they do this while they are applying active listening skills as well. So balanced communication fosters mutual respect and ensures that all parties feel heard and they are valued. They believe in the process, they trust the process, and of course, when that happens, the result is an amicable solution, a successful mediation process. All right, so that's about communication in mediation. We'll move ahead to emotional intelligence. But before that, I'd like to pause. Is there any question? Is there contribution, comment, observation? If I'm too fast, you let me know. If I'm too slow, you let me know. If you can't hear me, you also let me know. So any of that, the floor is open. Okay, so I can't see any response either directly or in the chats. So I'll go ahead. So we'll go down to look at emotional intelligence. So when you talk about emotional intelligence in the
Question.
mediation, sorry.
Hello, a question.
Okay, please go ahead.
May I know where a mediator engage two parties, then the one party decide not to open up effectively? It's like anytime the other party, one party want to talk, it's like there's itches always on anger. It's like in the mind of the one party, things that you are trying to defend the other person rather than that party bringing out the issues for you to know what exactly the issue is. In this situation, what will you do as a mediator?
Okay, thank you so much for that question. Uh, from what you are saying, it means that the party has come to the mediation table with a mindset, right? If you remember, I mentioned at the beginning that when parties come to the mediation table, when conflicting parties come to the mediation table, they come with different mindsets. There are high tensions. There are even those that do not even believe in the process. They just feel like, okay, the first reaction when people have conflict most times is, oh, let's go to court, let's go to court. So sometimes when they even agree to come to mediation, they don't come with like full belief in the mediation process itself. So they are looking out for those situations where they would see signs of bias, maybe in the mediator himself or even the parties, right? So the scenario you have presented is clearly one where the party feels bias, isn't it? If I got you correctly. Are you me? That's the role of the effective communication. The body language of the party, that kind of thing. So you handle that mediation by trying to build rapport between the parties, right? That's an effective skill for a mediator in that kind of situation. Your ability to establish relationship of confidence and trust. Trust not just in you as a mediator, but in the process itself. So you understand, you develop that rapport, you build that trust and confidence with the parties. When you do that, you enable them feel understood. They are able to give you more information. You're also better to understand their, the beginning, your opening statement and all of that. Right? You emphasize all of that so that you do not know any of the parties anywhere, or you are not related to them in any way. You clearly outline all of those at the beginning of those issues or those points at the beginning of the mediation process, so that the party is not getting to feel that, oh, maybe you are biased towards them or you are impartial in any way. So I don't know if I've answered that, but basically when you establish all of that, establish your neutrality, establish your impartiality, establish your role as a facilitator, not a judge. You are there to just facilitate, to guide them towards understanding their underlying issues and arriving at an amicable settlement. Then you are able to, through all of those actions, establishing a conducive environment and all of that, you're able to build rapport. And that rapport leads to trust and confidence in you as a mediator and in the process of mediation. So I don't know if I've answered your question. Hello? Please, can you hear me? Uh-oh. I can't see or hear any response. I hope it's not network anyway.
No,
Okay,
you
so
can
we'll go
be heard.
ahead
You can
to
be heard. Go ahead.
emotional
Yes.
intelligence. Oh, all right. Thank you.
Yeah.
Thank you so much. So we'll go ahead to emotional intelligence. Before now, we've established that there's a synergy between emotional intelligence and effective communication. So when it comes to conflict, I can't seem to hear. Okay, so emotional. When it comes to emotional intelligence, when it comes to interpersonal conflicts or conflicts generally, emotional intelligence is a crucial factor. Okay, please mute. You're interrupting the class. Thank you. Thank you. So, by way of introduction, emotional intelligence applies generally to conflict, especially interpersonal conflicts, and is a very crucial factor for mediators in navigating and resolving disputes effectively. So it's good for parties to be emotional intelligent, and it's also very effective if the mediator possesses emotional intelligence as well. So we have seen greatly from effective communication that emotions influence conflict dynamics. When people come in with high emotions, tensions, and all of that, it will affect the way they are able to respond to discussions. It will affect the way they are able to move positions, to shift positions from that adversarial position that they came in with to a position of interest, and where they are able to negotiate, where they have gained clarity and they are able to negotiate and all of that. So emotional intelligence generally, affects conflict dynamics, and then it goes ahead to shape how the individuals or the parties, conflicting parties, perceive, react, and manage their disagreements as well. So a high level of emotional intelligence will help parties to understand and regulate their own emotions while they are also empathizing with others. So basically, I always like to look at emotional intelligence, simply defining it as the ability of an individual to manage their own emotions in addition to the emotions of others. So, in summary, if you allow me, I will just end this class with that definition. So, once you hear emotional intelligence, forget all of the components, forget all of the explanations. It's just simply telling you about the ability, the capacity of an individual to manage their own emotions, to also manage the emotions of others as well. So that's where sensitivity comes in. You understand how you feel and you understand how whatever you do also affects the feelings of the other person. So generally, when it comes to emotional intelligence or emotional intelligence quotient, as they call it, it refers to, by way of definition now, a formal definition, it refers to the ability to perceive, control, and evaluate emotions. Emotional intelligence can be learned and strengthened. So it's not something that is naturally, it's not really inborn. It's something that can be learned, it's something that can be developed, it's something that can be built over time. And there are a whole lot of scholars that are linked or associated with intelligence, even long before Daniel Goleman. But we'll focus on his um, impact regarding the concept of emotional intelligence. And most people like to say that he termed or he coined the term emotional quotient and likens it to traditional intelligence that is also known as IQ, intelligence quotient. So emotional intelligence is about how smart we are or how smart an individual is with human connections and how smart they are able to manage themselves and their relationships. So the more emotionally intelligent a person is, the more effective they will be in communication. So you can now see the synergy between effective communication and emotional intelligence. If you look at a typical mediation setting, with the emotions, with the attitudes, the different perceptions, the values, the beliefs that parties bring to the mediation table, then as a mediator, if you are not careful and if you are not emotionally intelligent, then you'll be forced to shift or take sides, you know. So you will be forced to be biased. But if you are emotionally intelligent, then you are able to subdue your emotions as much as possible to remain neutral, and then to also make sure that you are to
Bench busy ya
hello.
what's nothing. Bench wa.
Okay, Dr. Gillian, are you saying something?
No, please, lawyer.
Okay, thank
Sorry.
you. Can we all mute? Thank you. Okay, so that's for giving us a background of emotional intelligence. So we'll try to understand emotional intelligence, and then looking at emotional intelligence, I like to look at the quote by Daniel Goleman himself. And he says that if your emotional abilities aren't in hand, if you don't have self awareness, if you are not able to manage your distressing emotions, if you can't have empathy and have effective relationships, then no matter how smart you are not going to get very far. So that's what Daniel Goleman says. And I think that to a large extent, I believe in that quote by Daniel Goleman. So it still brings us down to the importance of emotional intelligence as a mediator, the importance of being emotionally intelligent, the importance of parties being emotionally intelligent, the place of emotional intelligence in a conflict situation or in the mediation process. So by developing emotional intelligence, individuals, the mediator can become more productive and successful at whatever they do. The mediator can become successful at facilitating the mediation process and helping parties to become successful and productive at the process as well. So typically, emotional intelligence plays a critical role in the success of the mediation process. It navigates interpersonal interactions and resolves conflicts generally. So we'll go ahead to look at the major components of emotional intelligence. So it's typically broken down into 4 major components. You'll see some studies have further broken it down into more than 4, but for this purpose, we're considering the 4 major components of emotional intelligence. So look at the first component of emotional intelligence is self-awareness. So this is simply the capacity to recognize and understand one's own emotions, understand your strengths, understand your weaknesses, understand your triggers, you know, just an awareness of how your environment makes you feel, how people's reactions or attitudes makes you feel, how a particular situations or specific situations make you feel. When you understand your own emotions, you understand your strengths, your weaknesses, your triggers, and all of that, it allows you to be able to identify not just your triggers, but it allows you to respond adequately to those situations. You are able to manage your reactions more effectively. So I have a friend who is a married person, and he would always say he has his emotions under check. Like, he's very self-aware, and to the extent that if he has an issue that is with his wife, a discussion with his wife, for instance, that is escalating and is going to that point where it becomes like a serious argument or a serious conflict, he has gotten so aware that he can just cross his fingers, maybe his thumb, and the next finger, and then once he does that, it helps him control, regulate his emotions such that he's on doors, he crosses his fingers, he's able to regulate his emotions, his response, or whatever that he wants to do at that particular time. So that's being self-aware that, oh, if I get to listen to somebody to the extent that maybe a discussion is going some type of way, I might react negatively. So you do something, or you are conscious of that situation. You can either maybe stay away from that situation, or just decide to be quiet and all of that. That's a form of self-awareness, allows individuals to and to help them manage their reactions more. If you are, as a mediator, you are attuned to your emotions, cloud your judgment, your emotions are in check, you can learn to respond at the appropriate actions. So the next component of regulation or self-management, so it involves managing your emotions in a constructive manner. So if you become aware, self-aware, you know your triggers, you know your emotions, you know your strengths, your weaknesses, then you are able to effectively regulate those emotions. You are able to effectively manage those emotions. Like with the example that I gave, he's crossing his fingers is an effort to regulate his emotions under conflict. That kind of involves managing your emotions in a constructive manner, particularly in conflict situations where you are maybe under stress. So there are conflict situations that are unexpected. Somebody just provokes you, and then you can react, and you will be justified because time you are so emotional intelligent and you have figure out those situations even before they happen. So it becomes, you practice it, it becomes part of you. So you are not caught off guard. Nobody just comes to you to provoke you or stress you, and then you just react negatively, because you have developed the ability to regulate your emotions regardless of the situation. So it includes controlling impulsive reactions, staying calm under pressure or disagreements, adapting to changing circumstances and all of that. And when you are able to effectively self-regulate your emotions, then you are able to approach conflicts or disputes with a level-headed perspective. You are able to prevent a situation or a likelihood of negative behavior or reactive behavior that can exacerbate tensions or accelerate tensions or heighten tensions. So self-regulation involves management, self-awareness. You are aware, you have come to know what your emotions are, your strengths, your triggers. Then you talk about social awareness. So social awareness basically, as a component of emotional intelligence, is your ability to recognize and understand the emotions and perspectives of others. I like to break at this point to say that when you are talking about the components of emotional intelligence, you have the first two components that are personal. They deal with your personal ability to regulate emotional intelligence, your personal needs. And then the last two components are have to do with relationship with others, right? So social awareness is ability to recognize and understand the emotions and perspective of others. So you're able to do well with being socially aware, being empathetic, which is a very crucial technique for understanding viewpoints, the viewpoints and feelings of those involved in the conflict. So, on the one hand, you are able to manage your emotions by being self-aware and regulating your emotions. On the other hand, you are able to manage the emotions and understand, recognize the emotions of other parties by being socially aware. So by accurately perceiving others' emotional states or the emotional states of other parties, you can respond in ways that acknowledge their concerns, that foster mutual understanding. So, like in the question that was asked with regards to one party feeling that the mediator is biased, if the mediator is emotionally intelligent, he would be able to recognize that this is the perspective of that party, this is the emotional state of that party, and then the mediator will be able to build that rapport, acknowledge their concerns, and then create an enabling environment that will foster mutual understanding to ensure that the party now believes in the process and also believes in the mediator as well. And of course, the last component of the four components of the last component making up the four components of emotional intelligence is relationship management. So it has to do with the skills needed to build and maintain healthy relationships. And one of such relationships, like we have mentioned before, is effective communication, and then larger extent conflict resolution as well. So in conflict situations, strong relationship management skills enable individuals to navigate disagreements constructively, negotiate solutions, and maintain positive interactions in the face of the numerous challenges that come with conflict or conflict dynamics. So I'll go ahead to look at the importance of emotional intelligence in recognizing and understanding emotions, right? So emotional intelligence is very vital, like we have established, for recognizing and understanding emotions through the various components that we have outlined. In recognizing and understanding emotions, your own emotions as an individual and the emotions of others. And this is very vital during conflicts or the mediation process generally. So awareness of one's own emotions helps to identify personal biases and reactions, Remember I mentioned at a point that for every um, uh, um, conflict or for every dispute that comes to you as a mediator, it's you are approaching it with a new mindset, with an unbiased mindset. You don't compare. So with if you are emotionally intelligent, you are able to keep your emotions in check to prevent you from comparing a particular issue with the other party, so that you are not found to be biased or found to be reacting negatively. So when you are able to put your emotions in check, you're able to influence how conflicts are perceived, how the parties perceive the conflict, and how they are able to also address the conflict. And then your ability to understand the emotions of others will also enhance empathy and facilitate effective communication, as we have established previously. And then parties are able to gauge how their words and actions impact others. That's where sensitivity comes in. They're able to be sensitive. They don't just say things and just allow it, just say it for saying sake and not care how it will impact on the emotions of the other parties. And then the mediator is able to understand not just their emotions but that of parties as well. And this enables a mediator to be able to think outside the box and guide parties effectively to achieve optimal results. So, by way of conclusion, I'd like to state that the ability of mediators to understand not just their emotions, but that of parties aids them to not only think out of the box, like I've mentioned previously, but it also guides parties towards achieving optimal results in mediation. And then by effective communication is the cornerstone of successful mediation, as we have established from the beginning of this session. It is at the heart of mediation. It is at the core of mediation. Without effective communication, the mediation process would amount to nothing. It will not be fruitful. It will not be successful. So mastering active listening skills, non-verbal communication skills, emotional intelligence skills, conflict resolution skills can enable the mediator to create an environment that is conducive to dialogue and agreement. So as a mediator, continuous development of these skills is not only important, but it also positions you to resolve disputes effectively, and it also positions you to empower parties to be able to communicate and then collaborate constructively. So like I said, you can maintain a checklist. Always assess yourself on how well you are doing with effective communication, with mastering your emotional intelligence skills in after every before and after every mediation process in your make it a lifestyle in your daily life. We go through as human beings, we resolve conflicts on a daily basis, whether it's a formal mediation process or it's in our families. As parents, we resolve disputes between ourselves and our spouses, between our children and us, or our children, their siblings. We resolve conflicts every day in our workplace, between colleagues, in church, and all of that. So there are skills that we have to make every day part of our life and our existence, and then we'll find it very easy to flow in the mediation process as well. So thank you very much for your rapt attention. Thank you for listening. This is where I call it put a stop to the session. Thank you. The room is open. Questions, contributions, and comments.
Bless you, madam.
Thank you so very much, ma'am. All right. So the class is silent, so I assume no questions. So at this point, I would hand over to Mr. Isaac. Mr. Isaac, if you can hear me.
Yes, I'm here. Thank you so much for your insightful presentation and also making yourself available at all times. God bless you. We hope to
Thank
meet
you,
you
sir.
again before the end of the class. Right.
Thank you.
So we are going to have the next section, which is supposed to be on role play. The next section is simulation and role play, right? So let me see. So the next session is on role play. So as the role play, there so as part of your assignment for today, we want you to go, when you go today, look for what case lodgement form is, what a request form or what a request form is, and design one for tomorrow. Invitation letter to respondent for mediation session, design one for tomorrow. So it's a research work that we're going to do. So today I've shown you consent to mediate, so also design one for tomorrow. Then writing terms of settlement, design one for tomorrow. So let's go to what I have here. So conducting mediation. So if we are talking about simulation. So if you are conducting mediation, if you are conducting mediation, what are the processes? How can people come to you, and what will happen? And at the end of the day, how are you able to manage those people? So we have taken you through the process, but how do you start before the process that we have shown you commences? Right. So conducting mediation, one, there are two ways. Either the mediation is as a result of, or it is happening as a result of a provision that parties have made in their contract, or in there are some clubs who have put maybe mediation in their agreement, or they have put mediation in a certain agreement that they have. So based on that, if you encounter such, then you should be able to handle them accordingly as it has happened. So if it is in a clause, you look at what the clause is saying. So what are the clause demand that you do? Then you do it accordingly as the clause demand. If it is coming from another way, then you also look at it. So what other way can the mediation also happen? So other way is that without a clause, they don't have any clause, they don't have any agreement. But can mediation happen when parties do not have any agreement to go for mediation? The question is yes, yes, yes. The parties who can come for mediation, whether they have an agreement. For instance, husband and wife are having an issue. Do they have to go and sign an agreement to say that in the event of a dispute will come for mediation? No. Mother-in-law, father-in-law, business parties and other things, sometimes they may not sign an agreement. But if you are a business party, you must sign an agreement to indicate that, so that in the event of a dispute, you know what to do and where to go. So based on that, you don't find yourself wanted. So it can be without a clause, or a dispute solution clause, or a mediation clause in a contract, in agreement, and however the relationship is, or without any clause or without any prior agreement. The person can just walk to you or walk into your office or walk to anybody and request that they want mediation. So if they walk to anyone and they request that they want mediation, then you help them to do that. So initiating the process with a dispute solution clause or mediation clause, one thing is you have to also understand is that is it going to be an institutional or ad hoc? If you are talking about institutional, it means that the mediation is going to take place within a center. For instance, the parties wrote in the dispute solution clause that in the event of a dispute, we'll use mediation, and the mediation will be facilitated by the African Center for Collaborative Dispute Solution. So it means that they will come to this center. So if they come here, then we are going to be the administrator of that mediation for them. And so that is institutional. Or parties may say that we'll go for mediation. So that is an ad hoc. The parties have not agreed on how the process, which institution will even help them to handle it. All that they have agreed upon is mediation. That's also it is an ad hoc process that the parties have agreed to use to resolve their matter. So once you are able to determine that, so then you can also have without a clause. So without a clause, normally they come to your office, they walk into your office, they come here and they narrate their issue. Then you help them to fill what we call the case lodgement form or request form. So your office must be able to have a request form where the parties can fill. In our center, we have what we call a request form that parties can what fill in order to submit their case to or for mediation. So I think let me show you a sample of we have an online form. Let me look for it. Okay. Okay, so let me show that, then we continue. So this is a practical side that I want you to understand. So whether they have a clause in their contract or not, we have this. I hope you can see the screen. Tell me what you see on the screen. Hello, are we there?
Yes,
Yes,
please.
we can see.
Can you share with me what you see on the screen?
Africa Center
Yes.
for Collaborative Disputes Resolution Case Request Form.
Yes. So this is a form that we have designed online so that anywhere the person sits, they can file their request. So they don't need to even walk into our office. So for instance, African Center for Collaborative Dispute Resolution Case Request Form. So we have that. It said that please kindly go through the request form carefully and complete it. Upon receipt of your request form, an officer will review it and feedback will be given accordingly. AfCCoDR bringing peace to every home in Africa. Then our contact details is there so that if you encounter difficulty, you can call. So here, so you see your email, then information, a claimant. We have explained a claimant information. So a claimant is the person requesting for dispute solution process, negotiation, mediation, arbitration at AfCourt, so that you know what you have to file to us. Then full name. If you are filing for or on behalf of an organization, please provide the organization detail, registered name, address, and contact details. Then date of filing, nationality, date of birth of the person who is filing, residential address, postal address, and GPS address, email address, WhatsApp number. Include a country code and mobile number. So you include a country code so that it will be easy. If you're outside Ghana, we can reach out to you. Then, have you exchanged document or written a letter to the respondent or any supporting document? If yes, attach it here in a single PDF file. Then, which process are you requesting? Negotiation. This is the most informal process where parties communicate directly to reach a mutually acceptable agreement. AfCourt support parties by guiding discussion, improving communication, and helping them find common ground. The outcome is voluntary and based on consensus. So it means that if you want negotiation, we are going to help you as an individual to do your negotiation. Then mediation. Mediation involves a neutral third party who facilitates dialogue between disputing parties. The mediator helps clarify issues, identify interests, and guide parties towards a mutual beneficial solution. The mediator does not impose a decision. The parties retain control over the outcome. It promotes cooperation and helps preserve relationship. Then if you want arbitration, arbitration is a more formal process where a neutral third party arbitrator hears evidence and argument from both sides. After hearing the arbitrator makes a binding and enforceable decision called an award. It is similar to court litigation, but typically faster and more flexible. So which one then you take? Right. The nature of dispute, whether it is family dispute, labor dispute, land dispute, commercial dispute, consumer dispute, ethnic dispute, chieftaincy dispute, religious dispute, or divorce settlement, you take. Then statement of claim. A statement of claim is a formal written document submitted by a claimant, the party bringing a case in a dispute resolution process such as mediation or arbitration. It sets out the facts of the case, what happened, the legal basis of the claim, law and contract terms or origin relied on, the issue in dispute, supporting details or evidence. Then remedy sought. The remedy sought refers to the specific outcome or relief the claimant is asking the court or arbitral tribunal to grant. This may include monetary compensation, damages, specific performance, ordering a party to fulfill a contractual obligation, injunction, order to stop or compel certain action, declaratory relief, a formal statement of rights. Then respondent information. Now the person that you are bringing information about the individual or the opponent you are filing the case against. So respondent name, then respondent email, postal address, mobile number, and WhatsApp, include a country code, then consent and authorization. So that is also another section necessary to commence the process. Do you consent that you have willingly given us authority to your data for the purpose of this dispute administration? If you take yes. Do you have authority to commence this process? Which form do you want to use for this process? Hybrid, online and physical, online and physical. Then filing fee. Request must be accompanied by a non-refundable filing fee of then family fee, family disputes, $500 or $50, divorce settlement, $700 or $70, social dispute or other not mentioned here, 500 or 50. Then commercial disputes, 1,000 Ghana cedis or $100. Payment platform has also been provided so that it is easy for them to make the payment, and you attach a proof of payment of filing. Then payment channel, Momo, bank transfer, so you take, then any comment, you can add it. So you can also select whether you want a copy of this filing or not, then you can you can now send it to us. When we receive this, then we get in touch with the other party. So when we receive this, we get in touch with the other party so that the other party will now respond accordingly if they are willing to go through the process. So if you file this, once we receive this, we send you an email to indicate that we have received your request, and we'll give you the period in which that we will be communicating with the other party and also give you a feedback. So if you communicate with the other party, so we can send the other party a letter, we can call the person through a phone call. And why are we able to do that? We are allowed to do that based on let me show you section. Based on section 63 of the ADR Act of Ghana, which allows that, and also the center rules. So let me show you section 63. So I'm going to show you section 63. So watch. So those who are joining outside Ghana, you can also find you have to look for the acts in your country and refer to that specific portion on initiating the process. So I'm using the Ghanaian one as example. So the Ghanaian law, when you look at the part 2 of it, so if you look at part 2 of it, it says that a party to any agreement may, with the consent of the other party, submit any dispute arising out of the agreement to mediation by an institution or a person agreed on by the parties. So you can submit the matter to an institution or an individual. So you can bring it to me. If I call the other party and the other party accepts, it means that you have referred the matter to me. Or our center, if you send it to us and we call the other party and they accept, it means that the two of you have agreed to do the matter at our center. So a submission to mediation may be made by writing, telephone, or other forms of verbal communication, fax, telex, email, or any electronic mode of communication, and shall briefly state the nature of the dispute. You see, so that's why we have made online platform available for people who want to file. Then a submission to mediation through telephone or any other verbal mode of communication, unless the parties agree otherwise, be confirmed in writing and shall state the name, so the name, address, including email address and telephone numbers of the parties, and in brief the nature of the dispute. Mediation proceedings commence when the other party accepts the invitation for mediation. So you can come and see us for mediation, but mediation cannot commence when the other party has not accepted the mediation. So an acceptance of an invitation for mediation may also be made by a letter. So the person who have also received the invitation can send us a letter, can send us a telephone message, can call us, or other forms of electronic communication. Now we have WhatsApp, fax, telex, and other email that can be done through that another electronic communication or even a WhatsApp message. So when that is done, then 6, an acceptance by telephone or any other verbal means shall be confirmed in writing, but a failure to confirm an acceptance in writing shall not invalidate the process or the proceeding. So one thing you have to know is that once you call somebody on phone and they accept to come for the mediation, and they are supposed to write to confirm that they will come. If they refuse to write, it does not invalidate the process. It does not say that once they are not right, they didn't write to confirm, it does not validate the process. No, it doesn't work that way. So it doesn't work that way. So you should understand that. Then 7, failure by the other party to accept the invitation to mediation within 14 days after receipt of the invitation or within the period of time specified in the invitation shall be considered to be a rejection of the invitation to the mediation. So you should understand that if you send an invitation, for those who are in Ghana, if you send an invitation to a party and within 14 days, you call the person and they don't pick, you send letter, you go, you try every means to engage them and they did not say any word within 14 days. It means that they have rejected to go through the mediation process. 14 days, 14 working days. So it means that you count. Weekends are not part, you count. So 14 working days. When it elapses, it means that they have rejected the process. So understand this basic principle that they have rejected the process. That's what the law says. And we look at section 64. 64 talks about reference to mediation by courts. So for those who are in Ghana, a court before which an action is pending may at any stage in the proceeding, if it's of the view that mediation will facilitate the resolution of the matter or a party of the matter in dispute, refer the matter or part of the matter to mediation. So court, if the court feels, so it's a discretion of the court, or a party can request, and if the court so agrees, and with the consent of the other party, the court will refer. So a party to an action before a court may, with the agreement of the other party, and at any time before final judgment is given, apply to the court on notice to have the whole action or part of the action referred to mediation. The parties can also jointly request that. So normally you will have the parties jointly requesting. One person will take the initiative, then the other person may agree or disagree. Then a reference under subsection 1 or 2 shall state the nature of the dispute, the monetary value of the claim, if any, and the reason for reference and the remedy sought, and shall have attached copies of the pleadings and any other document the court considers relevant. So that is what this one also means. So if you look at section 65, it talks about the number of mediators. Unless the parties otherwise agree, there shall be one mediator. So if the parties decide to take 5, 10, but in the event that there is a default and they don't know how to appoint, it shall be what? 1. Then where there is more than one mediator, the mediator shall act jointly. That's what I was telling you, that you cannot go and say that you are the chairman mediator. The mediator should act jointly as co-mediators, not the mediator chair plus subordinate mediators. No, it doesn't happen. The law does not allow that. Then we have appointment of mediation. The parties to a mediation may appoint any person. So it is the parties that appoint. So parties to mediation may appoint any person or institution the parties consider acceptable to serve as a mediator. It is the parties' autonomy to appoint somebody, someone, who, specific person, as their mediators, not somebody saying that I know that you need a mediator. No. Then 2, parties may also request the assistance of a suitable institution or person in the appointment of a mediator, and may in so doing request the institution or person to recommend the names or provide a list of suitable persons to serve as mediator or to conduct the mediation. So parties can also waive their right and say that we know that we have been in the industry for long. Help us to find a mediator with this background to help us, also provide us a list, or you can contact an institution to provide them with a list, or they can contact an individual to provide them a list to conduct the mediation for them. Then 3, parties to mediation may adopt the mediation rule in the 4th schedule. So there is a 4th schedule mediation rule parties can adopt to use, or they can decide not to use the 4th schedule rule. So there are other things that those who are in Ghana look for this act and read. It is not any difficult thing. So you have to read, understand, and use them. So in the same way, assuming it's a foreign mediation and it is being governed by the UNCITRAL rules 2021 on mediation. So you just go to the net and search the UNCITRAL mediation rule on mediation 2021. You can just find them here. So this is it, UNCITRAL mediation rule 2021. So assuming if you are filing a case or you see a dispute resolution clause and they are saying that they are going to use the UNCITRAL rule, then it means that you go and look for the ancestral rule in force. So you see that. So you see one, application of the rules, commencement of mediation, number and appointment of mediators. So you go here, you go to, so number one is application of the rules. Then Article 2, commencement of a mediation. So in the respect of the dispute that has risen and shall be deemed to have commenced on the day on which the parties to the dispute agrees to engage in mediation, unless otherwise agreed. If a party have been invited another party to mediate and does not receive an acceptance of invitation within 30 days from the day on which the invitation was sent by any means, that provides for a record of its transmission or within such period of time as specified in the invitation. The party may elect to treat this as a rejection of the invitation. So Ghana law gives how many days? 14. The ancestral rule gives what? 30 days. So if parties have committed themselves under the ancestral rule, then you know that the parties have given themselves 30 days to consider a matter as a rejection. If within the 30 days the parties decide to reject, then within 30 days, it means that they have rejected the invitation. Then Article 3, number of an appointment of mediators. So there should be one mediator unless otherwise agreed. So this one is in line with what Ghana also has. So these are some of the things that we want to open your eyes on, so that as you go into the practice, you know that there are local laws and there are also international laws. So those of you in your country, look for your local laws. Look for your local laws on mediation, right? So let's go back to the presentation. Today we will end at 4 exactly. Okay. Right. So once there is a walk-in without a clause, so filing, you file a case for them. Either you give them your form to fill it online, or you fill them a physical form. A mediator or center getting in touch with the other party. Then pre-mediation conference or selection of mediator will take place. Then selection of rules. Then signing of consent to mediate, governing the mediation process. Selection of governing law. Then the mediation process will follow. Then you get an outcome. So before you go into the case study or you go into any mediation, you are supposed to have what we call a checklist. A checklist. So a checklist is you, the parties, you, the mediator, preparing yourself to know that when I move, especially when you are a beginner mediator, you know that when I go, I welcome the parties first, and then I will introduce myself. I will educate them about mediation. I will tell them about my credential. I will tell them about the ground rules. Then I will make sure that they sign the consent form, and I will make sure that they do this. At this point, I will transition to the next stage. At this point, I will do this. And that is what we call checklist. That is all. So that is what we call checklist. So with this checklist that I'm showing you on the screen, tomorrow, I want you to also be able to prepare your own checklist. So for instance, this is my own, which I developed, that when I meet the parties, first, I am going to welcome them. So welcome the parties, number one, then introduce us. So welcome, as we discussed earlier, my name is Isaac, and I'm happy to be your mediator. May I know your name? So introduction, so you have welcomed them, you have introduced, done the introduction, you educate them about mediation, your role, experience, and the center, and add your experience to it. So these are some of the things that you do. Then you move on to the ground rules. So that is what you use the consent to mediate form to talk about what is on the form gradually. Then you finish. When you finish, you can add auxiliary matters like washrooms, water, medical matters, and other things. then they sign the form. So they have to sign. Once they sign, some people may say that let's go through the mediation. We don't want to sign anything. No, let them sign the consent. That is your authority as a mediator. That's what they have given you. That's your power to sit with them. Because if they don't sign consent to mediate, later somebody can challenge it that no mediation happened. So that is also something to. Then you transition. Once they sign, their readiness to continue with the process. Are we ready to continue with the process, or we want to meet another time? No, if the time is right for them before beginning. So the party statement. So the first speaker, the claimant, and then the second speaker, which is the respondent. Then summarize what was said and create an agenda. So you summarize what they will say, you create an agenda. Now the discussion of the agenda, that is where the parties talk to each other. Then you generate options from the discussion, look for possible area of agreement, and look for areas that they disagree. Then search for solution to areas where both parties disagree, draft your possible solution or outcome, read it back to the parties for confirmation for the necessary corrections, then finalization of terms of settlement and signature. Then closure, give each party a signed copy of the terms of settlement. Then what you do is that photocopy or print out a signed copy of what both parties have agreed or the terms, and make sure you give each party a copy before they leave the session. Yes, so these are the steps again that I have brought. That opening statement, you welcome the parties. So parties, you welcome them, your opening statement, establish the post protocol, establish confidentiality, confirm authority, confirm time, prescribe your role for the mediator and the parties, transition. So uncover stage, ask what are you here to resolve today? Listen, look at the speaker, no notes, acknowledge after each party speaks, thank you. Reframe to neutralize the word or create title for each conversation. Confirm and write circumstances on chat. Then we go to the learning stage. The significance of the circumstances, parties now talk to each other, remind the parties of the ghost protocol, invite the speaker to talk to each other, tell each other what is important to you, listen, look at the listener, wait, can take note, trust in the process, wait, let them talk, support conciliatory gestures when left unnoticed by the other speaker, then confirm prospects on chat, then search possibilities. Your opportunity now is to generate options that will meet your unique and common needs. I will capture your ideas here on the chat. What can you do? Looking at this, or that. Then at this stage, alternative or possible solutions must be generated. The process works best when there are ideas to work with. Write down all the options and analyze each with the parties. Then ask what do you agree to do at the explanation stage. What would you like the plan to say? Confirm the plan by reading it to them. Confirm commitment to the plan. Then closure, review the purpose, review the process, tear up the notes to confirm confidentiality, confirm feasibility and authority to implement the plan, and treat parties to use the protocol techniques to deal with one another in another circumstances that may arise between them. Then, so that is what we have found ourselves in. So now coming to the case study. Yes, so I know today we haven't had much break, so we would like to end here so that whatever we have done today, assimilate them. So as I indicated, go and prepare request form, case lodgement or request form, consent to mediate, invitation to the parties, and also add checklist as your assignment so that you go and rest. Tomorrow morning by 9:30, we'll start. Then we'll start from the role place. We'll do discussions as we move on. All right. So if any question, please, you can ask now.
Yes, a recap. You said request form, invitation form.
A request.
Hello.
Request for mediation form.
Request form for mediation. Then invitation Invitation what?
Invitation. Invitation to the respondent. Invitation to the respondent. Consent to mediate.
Consent
to mediate. And checklist.
Okay. Thank you, sir.
Okay, thank you. So please, any other question? Also put them in the chat. Okay, so if there are no other questions, please, you can put on a video. Today we haven't taken a picture. Let's take a picture and we'll say bye-bye. Okay, so those who are able, please put on your videos. We take a picture. Then we are out of here. Okay, we are ready.
Yes,
okay.
sir.
Okay, so good to see all of you.
I'm not seeing my colleagues. I can only see you, Presto.
Okay,
I thought you are bringing all of us together.
Yes. You have seen Mr. Irenchi, you have seen Christine, and then Madam Veronica is off. Gloria is off, and there are other people who are also off. Okay.
It's
All
only
right.
Madam Gloria. I've seen her video. I've seen her. That was yesterday. The rest have not seen their faces.
Okay.
So you prefer
Is it raining in Zambia too? Okay, so let's take the picture in 2, 3, 1. Okay, thank you. So see you tomorrow. Enjoy the rest of the day.